We're on the record. Good morning, everyone. As chairperson of the Alcoholic Beverage Control Board for the District of Columbia, and in accordance with the DC Code Section 2571 of this of Subchapter 4 Open Meetings Act, I, wel I welcome you to the regular scheduled meeting of the Alcoholic Beverage Control Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Additionally, Section 1-3 of Mayor's Order 2020-00, Mayor's Order Section, Mayor's Order 2020-065, mandating the use of Octo-approved technology for virtual meetings remaining in place. And finally, electronic meetings by the ABC Board are also authorized under Title 25, which is 25-204.1, Board Open Meetings. Pursuant to DC Code Section 2576, notice of today's meeting was provided 48 hours in advance of the meeting on ABRA's website and on the District Central meeting calendar. The notice included the time, date, agenda, and a call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson, and I'm chairman of the board. I would like to introduce the other members of the ABC board who are also participating virtually. Please respond when I announce your name. Mr. James Short.
Mr. James Short, present.
Mr. Bobby Cato.
Bobby Cato, present.
Ms. Rafi Crockett.
Rafi Crockett, present.
Ms. Jenny Henson.
Jenny Hansen, present.
Mr. Edward Grandis.
Edward Grandis, present.
The board has 6 members in attendance for the attendance today, which constitutes a quorum for the purpose of conducting business. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 10 cases scheduled for this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first order of business today, it is a protest hearing status. This is case number 22 PRO 0001, Zoka and Crush by Zoka, license number 119693. This case has been canceled. The board was provided an offer in the board was provided a settlement agreement that will be considered. The next case in our calendar is a protest hearing, another protest hearing status is case number 20 PRO 00016, Cloud Restaurant and Lounge Sports Bar. This case has been canceled and continued to April 20th, 2022 at 10:30 a.m. at the request of the protestant with the consent of the applicant. The next case on our calendar is we now move to a show-cause hearing status calendar. It's case number 22 CMP 00004 Flavio, license number 8004. Can we please elevate the rights of the government and the licensee in this case, please?
Good morning, board members. Please stand by. Meki Karachu, your rights have been elevated. And Colin Sensi, your rights have been elevated. That is all, Mr. Chair.
Good morning. Mr. and Mrs. Karachu, can you please turn your camera on, please? Good morning. All right, good morning, everyone. Mr. Sansi, can you please spell and state your name for the record, please?
Morning, board members. This is Colin Chenci, COLLINCENCI, appearing on behalf of the District of Columbia.
Good morning, sir. Mr. Caracho, can you please spell and state your name for the record and identify what's your relationship to this case, please? You're on mute, sir. Unmute yourself, please.
I'm sorry about that. Can you hear me now?
Yes, sir. Go ahead.
Oh, thank you. My name is Mohammed Meki Karakshu. I'm the president of the company Melbourne Inc., doing business as Flavio Restaurant.
Can you please spell your name for the record, sir, please?
Yeah, MEKKI, last name KARRAKCHOU.
Good morning.
Good morning, sir. I have
Yep, I'm sorry, sir. What were you saying?
I've talked to Ms. Shani Brown this morning, and we agreed on the fine to be paid.
All right, hold on 1 minute, sir. Hold on. Thank you.
Yes, sir.
All right, Mr. Tenchu, this is a status hearing. Are there any preliminary matters in this case, sir?
Excuse. I'm sorry, sir. I couldn't hear you.
No, sir. I'm speaking to the government attorney, sir.
Oh, okay.
Hold on, please, sir. Are there any preliminary matters in this case, sir?
Yes, Chairperson Anderson. The parties have agreed to an offer in compromise just this morning. If the board is comfortable with it, I can read the terms onto the record.
Yes, sir. Please go ahead.
All right. In relation to the first and only charge of failure to keep a licensed ABC manager on duty at all times, licensee is going to agree to pay a $2,000 fine made payable within 120 days of the board accepting the offer in compromise. If the payment is not made within 120 days, the license will be suspended until payment is received.
Thank you, sir. All right, now, Mr. Karachu, it's my understanding that there is an offer in compromise, and the offer in compromise is that there is a fine of $2,000 payable within 120 days. If the fine is not payable within 120 days, the license will be suspended until the fine has been paid. Is this your understanding, sir, of the offer in compromise?
Yes, sir, I do.
Are you aware that by accepting an offer in compromise that you're giving up your right to a hearing?
Yes.
Are you also aware that by accepting an offer in compromise that you're giving up your right to appeal this matter?
Absolutely, sir.
All right. With that said, any questions by any board members? With that said, I'm therefore making a motion that the board accepts the offer in compromise of a fine of $2,000 payable within 120 days. If the fine has not been paid within 120 days, the license will be suspended until the fine has been paid. Is there a second?
Ed
Short.
Grandis.
Mr. Grandis has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. I want to thank the parties for having this offer in compromise, and sir, you have 120 days from today to pay the license. Thank you very much, and to pay the fine. Thank you very much, and have a great day.
Thank you, sir, as well, sir. Thank you.
Thank you, sir. All right, our next case is case number 21 CMP 00076 and case number 21 CMP 00078. Ms. Foshburn, can you please elevate the rights of the license in this case, please?
Sidon Johannes, your rights have been elevated. That is all, Mr. Chair.
Thank you. All right, good morning. Good morning, Mr. Senchu. Can you please state your name for the record, please?
Yes, Colin Chenci, COLLINCENCI, representing the District of Columbia today.
Thank you, Mr. Senchi. Ms. Johannes, can you please spell and state your name for the record and your relationship to this licensee, please?
Peter and Johannes here on behalf of the licensee, and that is SIDONYOHANNES.
All right, so now this is for case number 21 CMP 00076. Mr. Senshi, are there any preliminary matters in that case?
There are no preliminary matters at this time.
Then this matter is scheduled for a show cause hearing on April 27th, 2022 at 10 a.m. I just want to remind the parties that 7 days prior to this hearing, both parties are required to exchange documents and witnesses to each side and also to the agency. If this is not done, unless good cause is shown, the board might not allow the other side to rely on documents and witnesses that have not been disclosed 7 days prior to the hearing. All right, thank you. The next case is case number 21 CMP 00078. For this case, are there any preliminary issues in this case?
Preliminary matters from the government.
Oh, all right, Ms. Johannes. All right, I'm sorry. All right, hearing that there are no preliminary matters in this second case, this case then is scheduled for May 4th, 2022 at 10:30 a.m. And again, just want to remind all parties that 7 days prior to the hearing, each side is required to exchange documents and witnesses. If that is not done, unless good cause is shown, the board might not be inclined to allow the side that did not disclose the documents to rely on documents and witnesses that have not been disclosed 7 days prior to the hearing. Everyone is aware of that?
Yes.
All right. Thank you very much, and have a
Thank
great day. Thank you very much. All right, the next case on our calendar is case number 22 CMP 00005 DC Food Market. This case has been canceled. The parties have submitted an offer in compromise for the board's consideration. The next case on our calendar is case number 21 CMP 00065 Empire Lounge, license number 110702. This case has been canceled. The respondent was issued a letter of warning and the government dismissed the case. And that is we're going to do a fact finding here in Mr. Senshi first. And then if the next case is your case, then we will call that case. Okay, sir?
Thank you. I don't believe I have any more matters today.
Thank you, sir. Have a good day. All right. So the next case in our calendar is case number 21-251-00041, Focus DC license number 118015. And Ms. Foshman, can you please elevate the rights of the parties in this case, please?
Please stand by. Nebu Ali, your rights have been elevated. Seth Anderson, your rights have been elevated. And Aaron Peterson, your rights have been elevated. That is all, Mr. Chair.
Thank you.
Good morning, everyone.
Good morning. Hold on. All right. Okay. All right. So let's have the parties identify themselves. For the record, I'll start with the investigator. Ms. Peterson, can you please spell and state your name for the record, please? Ms. Peterson, can you please spell and state your name for the record, please?
Sorry, Mr. Chairman, I was on. My name is Erin, E-R-I-N. My last name is Peterson, P-E-T-E-R-S-O-N.
Thank you. Ms. Johannes, can you please spell and state your name for the record, please, and who you represent?
Cedar and Johannes on behalf of the licensee, Sidonyohannes.
All right, Mr. Ali, can you please spell and state your name for the record and your relationship to this case, please?
Sure. My name is Nabiu Ali, N-E-B as a boy, I-U. Last name is Ali, A-L-I, and I'm the president of DC.
And Officer Anderson, can you please spell and state your name for the record and your relationship to this case, please?
Yes, good morning. My name is Seth Anderson. A-N-D-E-R-S-O-N is the last name. I'm a lieutenant with Metropolitan Police Department, and I supervise the area of PSA 104, which contains within it the Focus DC Club.
Thank you. Good morning. All right. All right. This is a fact-finding hearing, and this is a fact-finding hearing that was requested by the government. By the chief of police, based on a matter that occurred at closing time, I think, on December 19th, 2021. And so I'll ask Ms. Peterson, can you just bring us, all right, and let me just inform the party, this is a fact-finding hearing, and the board has not made, it was a request for a fact-finding hearing by the chief of police. The board at this juncture is just conducting investigation to get some background information regarding this matter. The board, however, during a fact-finding hearing, none of the witnesses are sworn in. We're just gathering information. The board cannot order the parties to do any specific action. The party, however, can volunteer. The party, however, can volunteer if the board asks, but the board in a fact-finding hearing cannot order the side to take any specific action. And as I stated before, we're just gathering information, and at the end of this hearing, the board will either take this matter under advisement, we can say no further action, or the board can refer this matter to the Attorney General's office for further developments to see if enough information was generated here for the government to file any type of specific charge against this entity. So is everyone understood where we are? Okay. And so what we'll do, I'll have the investigator, bring us up to speed where we are, while we here. I would ask Lieutenant Anderson if there's any supplement that he can provide as far as the chief of police, why a request was made for this fact-finding hearing. Then, Ms. Yohannes, on behalf of your client, you can choose to state a position of the agency, on the applicant, where we are, okay? All right, so we'll then start with the investigator, so the investigator can just give us a summary of why we're here this morning, please.
Yes, sir. On Sunday, December 19th, 2021, approximately at 3:09 a.m., an assault with a dangerous weapon occurred outside of Focus, D.C., which is located at 1348 H Street, Northeast, Washington, D.C. Specifically, 2 male patrons were seen exiting the establishment, and they became involved in an altercation outside of the location and ended up with 1 male who was shot and was wounded. The victim departed from the scene, but was later located at an area hospital suffering from a non-life-threatening injury. MPD, Metropolitan Police Department officers nearby immediately responded to the scene, but they were unable to locate the suspect in an effect of an arrest. No violations of ABRA regulations were substantiated. This determination was based upon my investigation and review of the establishment security footage and interviews, and also interviews with MPD officers and detectives of the Metropolitan Police Department.
All right. Lieutenant Anderson, from your perspective, and again, this is a fact-finding hearing was requested on behalf of the chief of police. can you just elaborate a little on why is it that the chief of police thought that it was important for us to have a fact-finding hearing on this matter?
Yes, and what Ms. Peterson, Investigator Peterson said is correct. All those facts are correct. The one issue that fact-finding letter from the chief of police was the fact that when the officers were investigating the initial scene, they responded over to the club to try to get that security footage. While they initially got cooperation, they also then, a few minutes later, after hearing the owner was en route, were told that the owner would not be en route and would be responding in the next day, and they could obtain the footage then. As far as an ongoing investigation or a fresh investigation that proved to be a hurdle to finding either a suspect lookout or a victim lookout who did later turn up at the hospital, but that did prove to be a problem in the initial investigation into the incident.
All right, thank you, Lieutenant. Ms. Johannes, any question that you, sorry, what is it that you have to say, if anything, on behalf of your client?
Sure. I will just say on behalf of my client that, Focus has been in operation for about 8 months now. Regarding the security footage, and I'll just get to the specifics of it because the one statement that was made, or the one reason for why we're having this hearing that I just heard, is that the footage wasn't provided, I guess, the night of. This is a CT license, or I'm sorry, a CCR license, and we are not required to have security cameras. So we have security cameras. The camera footage actually records for 8 days, and Mr. Ali was the only individual at the time who had access to that and who could provide that. I want to ask Mr. Ali to speak on this, and I will have I can question him, or I can have him elaborate regarding the details of what happened that evening. But I will say he left at 2:30 in the morning, around that time period. I think there was some miscommunication as to whether he was going to circle back and come right back to the establishment, but he immediately, later that evening, so the shooting happened December 19th at around 3:09 a.m. Later that afternoon, evening, footage was provided to MPD, and thereafter was also provided to ABRA upon ABRA's request, when ABRA requested it. So I will also say, and I can, if you want to question my client, you can, but efforts have also been made to ensure that a manager on duty can now access that footage immediately. And efforts have been made to change their process to where they can access footage, or the recordings will be longer than the 8 days it initially was for. So that problem won't exist anymore. They will be able to provide footage immediately. In fact, I believe about a week or so ago, they provided footage to MPD that helped in a murder investigation. And they were able to assist in that, and they did so. And that had nothing to do with their establishment.
Does Mr. Ali have anything that he wants to say? I have some questions that I want to ask, though, but if you had stated that he could speak on this matter.
Sure.
Yeah.
Go ahead, Mr. Ali.
Thank you for giving me the opportunity to speak. I mean, Sedone, you kind of, hit it in the nail. Basically, experience is the best teacher. I found out that, I needed to have my management have access to my videos. I was the only one with access to it, as far as like manipulating, when it comes to like rewinding and doing all that stuff. I was the only one that I could do that. My managers can still look at the video, but they couldn't really go in depth. After that day, now, more than one of my managers are able to do that. So if anything was ever to happen, we wouldn't have the issue of we got to wait until the owner comes back, which I did the next day and, cooperated to the full extent. We're known to be actually a venue that cooperates a lot. Anything happens around that area, because cameras are good. We do have, MPD come and ask us for footage, and we have provided, as she said. We want to obviously comply with all the rules. We want to be a great addition to the community and not hinder any law enforcement from doing what they need to do to keep us safe. I mean, we know we're not in the best location in DC, so we definitely want to work hand in hand with the police department to make sure that our area is safe, really.
All right, Mr. Ali, I just have a couple of questions I want to ask you. Now, as was stated on the record, that you have just been have been in operation for 8 months prior to this incident. Is that correct?
Yes, sir.
Now, and it's stated that you are a CR, meaning that you have a license to operate as a restaurant. Tell us, just describe your business model and what are your hours of operation, please?
Hours of operation right now. So what I guess if you can give me 5 to 10 minutes, I can kind of elaborate what we're doing now and what we plan to do.
You 5 to 10 minutes. I asked you one question. It shouldn't take you 5 to 10 minutes to answer the question, but I'm asking you to let us know your business model, so maybe you can go ahead.
So our business model, when we started, we had to put it on hold due to COVID because we weren't getting any customers coming in early on. But our business model is to open up at 11 in the morning, operate more of like as a internet cafe / restaurant / like coffee, like a coffee spot where the young generation can come in, do their work, study, hold meetings, things of that nature, and then break into the brunch, the lunchtime, where we're open for the community as a place where they can come and eat lunch. We do have 3 floors, so we're able to accommodate different ideas on each floor. We did open up as that, and I mean, we've just lost so much money. Not a lot of people are coming into whether it be to study or to eat as much as we would like. So now we're doing more of like a dinner establishment where we open at 4 or 5 p.m. People will come in, do a happy hour, do dinner, and then go into the late night, where after dinner we'll have music, and kind of like we try to trap customers to kind of stay and hang out and have fun.
So what time you're scheduled to close?
We close at 2 on Thursdays. Friday and Saturday we go until 3. Sunday we close around like 11, 12, depending on, it kind of dies out around like 10 p.m., 9 p.m. But we try to milk it as much as we can. But we're hoping that things get better soon.
But I guess what I'm trying to find out, what happens late night? I mean, is this are you serving food when, I mean,
Of course.
Are you serving food, and what kind of food are you serving late night?
So we do have a brick oven pizza, which is the main attraction in that place. Before I became the owner of that place, the place is known as Red Rocks, as the pizza joint. So we did kind of stick with that vibe. So a lot of people do come, even from H Street, walking in and just order pizza, sit down and eat pizza, drink, and listen to music and have fun.
So what else is on your menu? You're a restaurant, so what else is on your menu?
We do have quesadillas. We do have salmon. We do have wings. I mean, I fought a lot to keep wings off the menu because chicken has become so expensive, but I mean, the people want it, so the profit is not all that, but we provide it. We do have a fritas. We do have steak quesadillas, chicken quesadillas. I mean, all our stuff was on our menu. I can go through it. We do.
Yeah, I believe there's a menu that menu that you provided, or we provided to Abra when the application initially was approved. That's the same menu you're currently using, right?
Correct.
Well, I'm curious. I mean, because this is typically restaurants are not open until 2:30, 3 o'clock in the morning. And so if a restaurant gonna be, so if it's a restaurant, the kitchen needs to be operational,
100%.
operational almost up through closing. I mean, it's that, so is the kitchen, what time is, if you're open till your hours, or if you're open till 2 a.m. or 3 p.m., what time is your restaurant operational till?
Until we close. I mean, we have people that do pizza carry out, and at the end of the night, take their pizza and go home.
Now, I guess what I'm trying to find out is that, does your establishment have an entertainment endorsement?
We do have an entertainment endorsement, meaning like, are we able to
Yeah.
DJs? Yes, we do.
Yes.
All right. So, and what time did this incident occur? Do you recall what time, what day of the week and what time did it occur?
I would have to look at the calendar. I believe it was a Saturday night, December 19th.
So December 19th and approximately, Lieutenant, do you recall what time, what time the incident occurred?
3:10 from what I'm understanding, right? 3:09.
3:10. 3:09.
That's correct. It was at 3:09 hours on the 19th.
This is after the let out is when the incident happened.
All right. And one of the things that I'm trying to establish, I know that because you have an entertainment endorsement, it appears that you might have late night entertainment. And so because you might have a late night entertainment, or there might be that because there might be late night entertainment and late night activities, people might not necessarily be sitting down at 2 a.m. in the morning or 3 a.m. in the morning having pizza. There might be others going on there. So there might be other activities going on there that we need to make sure that as a new license holder, that you're protecting yourself and protecting your clientele. So during late nights, or say after 10, can people just walk through, or is there some type of security procedures that for someone to enter the establishment? Is this occurring, or I'm just trying to find out.
If I may, can I have Mr. Ali speak about security procedures in place? If there is, because there is entertainment, there is sort of nightlife activities, and that it sort of goes from it's not a sit down, as you're saying, from the sit down establishment to something else, or just sort of dancing or whatever it is, entertainment, right? So you want to know about security procedures. I think there's adequate security, and he can tell you about the type of security there is. I think even in this report, ABRA investigator Peterson has indicated when interviewing the MPD officer from across the street, even said to this investigator that Focus usually does have adequate security. From what they witnessed. And there is also RDO that's usually that he has, and they were not available on this night, or they were not there on this night due to some payment issues. However, RDO is there regularly, and they are there regularly now. Do you want him to speak on that, and do you want him to speak on security?
Yeah, let's talk about security, and just let me get some. Now, do they voluntarily have RDO?
Voluntarily.
In order to have RDO?
It's voluntarily.
Voluntarily. Our security kills me. But I've been in the promoting business for about 10, 11 years, and I've worked in all the clubs in the city. And one thing I've learned is that it costs to be safe. And that's one thing I don't take lightly. I mean, my security expense, You know, I get into argument with my wife all the time. Baby, why do we need all of this, all of these securities? Nothing ever happens here. And my argument to her is, baby, all it takes is for one thing to happen one day, and we put everything we worked hard for at risk. So I do have 14, 15 securities. That night, actually, we ended up having, when we counted, I think maybe 17. But I do have 14, 15 securities on weekends just to make sure, because I know we're not in the safest neighborhood in DC. A couple of blocks down from where we at, you know, things go down all the time. So I try to make my clients feel comfortable and safe by, you know, making sure that we have 3, 4 securities at the door, usually patting down, checking IDs. Everyone gets patted down to come in. Everyone.
Those are your entry procedures, correct?
Yes, everyone. It doesn't matter who you are. You can be, you know, someone that's kin to the owner. You can be someone that's best friends with one of the employees in the establishment. It does not matter. I'll tell them everybody got to get patted down. So as far as security, we do extremely well. We do have, again, the police officers come, and I appreciate you guys for, you know, covering half our cost as well. Just it deteriorates a lot of people from wanting to do wrong things when they see an officer at the door. I understand that from being in the business for a while. So with security, we don't play.
So you have security that you've hired, you have RDO, and you have cameras. That's correct?
Yes, ma'am.
But, all right, but one of the issues that your state of the cameras, I don't record for 8 days. So has that been changed, or is it for now for a longer period of time?
So we've ordered servers that allow us to record for 28 or 30 days or more than that. So our cameras used to record for about like 2.5 weeks, 2 weeks. But what I did was I added the sound options to it, so I can actually like hear some, you know, conversations, and that took up some of my space. So now, you know, I told them, I said, I don't care about the sound anymore. I just need, you know, the footages. So we're going to be able to do, you know, 30 days very soon. It's already.
Go ahead, sir.
How many cameras do you have?
We have 30 cameras.
All right. And and again, Ms. Johannes, I'm hearing about security, and I'm hearing about cameras, and I'm hearing about RDO, and this is a CR license. So
Correct.
it's not the typical operation, at least in my view, of a CR license. So based on what I'm hearing, would your client agree to file a security plan?
We can discuss one. However, it seems that we've abided by all requirements of what a security plan would even entail.
Well, but if as you're saying you're abiding by it, why not file a security plan with the agency? The reason I'm not, as I stated before, you can say yes, you can say no, but you're saying what I'm hearing from you, we're doing everything that a security plan would ask. So if you're doing it, what's wrong with filing one with the agency?
Well, my client, and I will say my client and I can discuss that.
All right, fine, thank you. All right, any questions by anyone, by the investigator, Lieutenant Anderson, or any board members of the licensing?
Mr. Chair,
Yes, Mr. Short.
thank you for allowing me to speak. Mr. Ali, good
Yes.
morning, sir.
Good morning, sir.
Okay, now you say you've been in the entertainment business in Washington, D.C. for a while, which makes you kind of savvy about what goes on when you have incidents and investigations and all those other things that occur when something happens in or around a ABC establishment. Is that correct?
Yes, sir.
So were you working that night, or were you at the club that night?
No, I had just left home.
So you weren't there at all that on the 9th? You weren't there at all?
I was there. I had just left maybe, 30 minutes before the incident happened or whatever the case was, but I was not there when this incident happened. But I was there that day for about 13, 14 hours from open to literally almost closed. So that day I left early to come back in the morning and open for brunch.
Are you also aware, even though it's, you know, it wasn't required of you to have a camera system, if you have cameras, they must work, correct?
Yes, sir.
And if you've been around, how many years in the business?
I've been in the business. I've been in the promoting business. You know, I've always worked for restaurant owners and club owners in my life. So, you know, I'm kind of new to being an owner. You know, which I'm thankful for having the opportunity to get here. But you know, I have been in the business for about 11, 12 years.
Okay. Well, Mr. Ali, don't you realize that some of the cameras can protect you and ward off some very serious lawsuits? If you have working cameras and someone comes to sue you or accuses your club or one of your employees of doing something, if the cameras are working well, it would help you.
100%.
So you have invested a lot of money in the cameras, correct?
Yes, sir.
But you were the only person in your business that could provide what the law requires you to give when there's an incident.
Yes, sir.
I mean, I'm a private citizen. I have cameras in my home, and if the police would come and ask me, I would be able to provide them any footage they needed at any time, because I realize it protects myself as well as my neighbors or any visitors in the community around my home.
And that's our plan as well.
You feel that same way too, correct?
100%.
And so you're the only one who can provide footage right now. If something happened, you would be the only one who can provide footage to the city?
Not anymore. I've noticed that was a mistake as of that day, but you have to understand, you know, we've been operating for 7, 8 months. I've been there every day, working 14, 15 hours on weekends, and it has never been a situation where I was never there and we had to provide these things. So it just happened to be that day that I was not there and things happened. And moving forward, if that ever happens, and you're right, people will have the footages right away. You know, there was nothing that we were trying to hide. I came and gave the
Mr. Ali, who currently has access to your footage?
My managers and assistant manager, 2 people have access right now.
Thank you. It sounds like you're being quite cooperative and you're heading in the right direction.
Thank
now,
you.
Your security persons you have there, you say 17 some nights or more or less. Are any of those persons registered with the District of Columbia that they've been trained in security?
I can confirm with Bird and get back to you guys through email if you like. I don't want to answer and it'd be wrong or right.
Well, this is just for your information. The DC City Council has considered or is considering or may be passing soon that security guards in the District of Columbia must be registered with the MPD. That way they have the proper training, and that way it protects you also as the owner, because we've had incidents where people have got involved with security and security was proven not to be able to handle the situation. But anyway, we hope that we never see you again for anything like this. But you might want to check and see if even all the security people you have are appropriately trained and can handle any situation.
Okay.
Does anybody on your staff know first aid or CPR or any of those other things should something happen inside of your club? I mean, inside of your restaurant?
I have one of my bartenders who is a main job is nursing. So I've never had this conversation with her, but I'm pretty sure, you know, if she's in nursing, she would know.
Okay, well, I can tell you from my experience in life, there's a little difference between operating or working on someone inside of a hospital, a very sterile condition, and working in a place outside of a hospital where you have emergency medicine. There's a big difference between emergency medicine where someone is stabbed or shot and working inside of a regular emergency room. So you might want to consider that also. But anyway, I thank you for your testimony. And again, you were there that day, but you just happened to leave before closing time. Is that correct?
Yes, sir. I was tired. I had to be back again a few hours later, so I was just trying to get home, get some rest.
Okay, thank you, Mr. Ali. Thank you, Mr. Chairman. That's all I have at this time.
Thank you, Mr. Short. Any questions by anyone else?
Mr. Chairman,
Yes, Mr. Grandin.
thank you. Investigator Peterson, hi. Thank you for
Yes,
your thank you for your information today. I have a couple questions that maybe you may have information on. If not, perhaps the lieutenant may. My understanding from reading the letter and hearing the testimony today is that the request was made for the footage almost at the time of when the police arrived. And if I read the letter correctly, you all were told that the owner would be sending that footage in a few minutes or something like that. Was there any understanding that the footage would be available that night?
So from my understanding as the investigator, I was told that MPD, and I was told by Detective Naples that before he arrived, Detective McLaughlin arrived and he requested the footage. He spoke to the ABC manager, Ms. Tolbert, and she proceeded as if she would assist them. And as she started to go up the steps, she was stopped and said, no, he's not here. We don't have access to the footage. But the officers were under the impression that they would get the footage that night. So I'm told that they called the owner, Mr. Ali, to say, hey, MPD's here, we have a situation, we need you to come back. And he said, which is what I'm told, is that he said, okay, I'm on my way. And then he called back about 5 minutes later and told them that he could not come back. However, he did provide them with the footage later on that day. Officers did tell me that. And so did Mr. Ali.
Did you observe the footage?
I did.
Mr. Ali, I understand you may want to respond, but I'm fine with your situation that you went home. So you did observe the footage?
I did.
And Lieutenant, did you observe the footage?
I have not observed the footage from inside the establishment, and I've seen the body worn camera from the video from the officers that responded, but I've not seen the internal footage from the club.
I have it.
I'm sorry.
I have it if you want to view it.
Okay. So what did you observe? Did you observe anything regarding the subject in the footage you saw?
So what I'm told, and I got from detectives, first of all, they sent me a still picture so I would know who the possible suspect was and who the victim was. I saw them exiting the establishment. I saw them heading westbound. They go out of sight, out of the camera footage. Once they go outside, I can no longer see that. So once the shooting occurs, it's kind of like a delay. I don't know if people were like, they didn't believe the shots or maybe it was a little further down, but everyone is kind of like standing there for about, I don't know, maybe like 10 seconds after the shooting happens. And then everyone takes off running and they get on the ground. Again, at this point, I still don't see the suspect. I can't see the victim. I only see patrons who are hanging out in front of the door because they have a camera facing down right at the front door.
Right. So let me make sure. I think I heard you say that there was some footage from inside that showed the picture that you believe was the subject inside the establishment.
Correct.
Okay. Mr. Ali, thank you. Mr. Ali?
Yes, sir.
I want to thank you for being here today to speak on behalf as the owner. It's very helpful.
Thank you.
Okay. If I heard you correctly, no one enters that establishment without being patted down.
Correct.
Well, we just heard the investigator saying that there is footage from that evening that shows the suspect inside. Have you seen that footage?
Have I seen the footage of the suspect being inside?
Yes.
I saw the suspect and the person that supposedly got shot talking and walking outside from this.
The footage, if I understood the investigator, she obtained footage from your establishment
Yeah.
of patrons inside. And she was able to recognize from a photograph, if I understood her correctly, of the potential subject being inside. Have you seen that footage?
No, you mean a potential subject as in like a gun? Is that what you're saying?
The person,
The person who shot. The
Yeah.
person who shot the victim.
So from what I understood from the detectives, the person that got shot and the shooter are supposedly friends.
I'm asking, did you see the footage of your own camera?
Yes, I saw them two walking out. Yes, sir.
Okay. But you also testified that no one gets in without being patted down.
Yes.
So I'm having a problem understanding how you had a patron with a gun inside the establishment.
He was not inside the establishment with a gun.
We don't know okay, how soon after these people exited, because you saw them exit, did the shooting occur?
The shooting occurred 10 minutes after we were closed.
So you don't believe that this individual had the gun inside the establishment?
1000%. It's
No, that's correct.
Well,
We also
let's be
have
honest.
we also have the investigator here and MPD, but my understanding is that I believe from one of the officers that they've stated that as well. I mean, the position is they understand that the individuals were inside and there are other vehicles outside of the establishment, but that the weapon was never obtained, and they don't believe that the weapon was actually inside of Focus.
Lieutenant, is that your understanding from the police? That they don't believe the suspect who is seen walking out with the victim did not have a gun inside?
Yes, sir. That is my understanding.
No, I'm sorry. I was talking to, thank you.
Okay.
But I was
Sorry.
talking to the lieutenant. Thank you.
Oh.
The lieutenant.
I'm sorry, Mr. Grandis. Ask the question again, please.
Before I asked the question about whether the subject was inside and you had footage of it, I was concerned that maybe this incident wasn't really related to the establishment. But we're being told now that the suspect and the victim are seen inside the establishment on the footage that the investigator just talked about. So if it's agreed that this so-called subject is the one who outside shot the victim, has the police made any determination on whether or not they believe the suspect had the gun inside the establishment as well? Or is there information the police have that the suspect went to a car or went somewhere outside and got the gun after leaving the establishment?
A lot of that is inconclusive. There were officers Officer Martinez was patrolling the 8th Street corridor. It was about 100 to 150 feet away from the crowd that had exited when the shots were fired. In his report and in the follow-up and what I've been able to see in the body-worn camera video, he states that people were standing outside, that he did not see anybody go to a car or the location to grab anything other than people exiting the club.
So it's inconclusive.
It's inconclusive. I've not asked him that specific question, but his report is fairly detailed and he does not indicate that anybody went to another location prior to the shooting
So
from where he observed them exiting the club.
thank you, officer. So I go back to Mr. Ali.
Can we go back to the investigator and Detective Nate, or maybe, I'm sorry, MPD, Detective Naples stated that MPD does not believe that the suspect carried the gun inside of Focus DC. And this is in the report.
I'm sorry, whose report is this?
This is the investigator's report.
Yes, that was what was stated to me by Detective Naples.
Which seems to be possibly inconsistent with what we were just being told
Right.
by the lieutenant.
Well,
Correct.
with Officer Martinez's report would be the initial report. Detective Naples would have done the follow-up investigation, and so he may have a more finely tuned bit of information to that regard. So his is the furthest along investigation.
And back to the investigator, in seeing this footage of the suspect and the victim inside, did it look like there was any altercation in communication, of body language, of any kind of tension between the two, at least from the footage? Or did it look like that they just knew each other or were part of the same group?
They absolutely look like they knew each other. The possible suspect, once they're seen exiting, they're probably a few centimeters behind one another, and the possible suspect is seen at the door once they get to the door to exit, like wrapping his arm around the victim. So it looks as if they knew each other to me, like they were friends. So
Okay. So get back to Mr. Ali. Mr. Ali, you have the understanding that the gun was not inside the establishment.
I mean, based on the tightness of our security, I find it impossible. I can never tell you 100%. At my establishment, because we really do pat downs, because we understand the nature, the location of our venue being so close to the hood. So it's impossible for that gun to be inside.
Well, I belabored this point because I'm concerned always that if there's an incident outside of an establishment, it's not always the blame of the licensee. You know, the licensee can only be in control of what's inside. So that's why I'm belabored this issue of whether the gun was seen inside or was, and I appreciate the information that you all have given me on that. So thank you very much. Oh, but one last thing. Investigator, did you look at what, I understand there's an entertainment endorsement. Did you look at what the endorsement allows?
No, not exactly, sir. I mean, everything is from Red. A lot of things are from Red Rocks. It's kind of like blurred, the typing. I could barely read it. My supervisor could barely read it. I'm sure if I show you guys, you can barely read the information located on the form.
Let me ask Ms. Jonas, have you looked at the license of this establishment?
I have looked at the license. I don't have it in front of me. I believe there's an entertainment endorsement that includes, it could also include both other endorsement and dancing and cover charges.
So okay, so
But
you
I
believe,
don't have the license in front of me.
but their license may allow a cover charge?
It may, but I don't believe that they do cover charges.
We don't charge anything for entry.
Okay.
Yeah, on their license, they only have entertainment and they have the holiday extension. They don't have cover charge.
And entertainment under a CR would be a DJ, I would imagine.
A DJ.
Yeah, we DJ, but we don't charge anything at the door.
Do you have a dance floor?
It's not really.
Base.
Do they allow dancing?
Say that one more time.
Do your patrons dance?
I mean, these days people don't dance like back in the days.
That's a difficult, there is no dance floor that's over 140 square feet, if that's a question.
Like, Ms. Johannes, you hit it on the head. You understand where I was heading on that.
Yeah.
So they don't advertise that they have a dance floor.
Correct.
Okay. I just really want to thank you for letting me explore whether the gun was seen inside or not, because I believe that's very important to make that determination. Thank you.
I appreciate it.
Thank you, Mr. Grandis. Any other questions by any other board members?
Mr. Chair, I had a question of the investigator.
Go ahead.
Investigator Peterson,
Yes, sir.
what are the hours of this establishment, the CR?
For that day, or
Yeah, for any time. What are their hours?
so Sunday through Saturday open at 11 a.m. Sunday through Friday they close at 2 a.m. and then on Friday and Saturdays they close at 3 a.m.
What day of the week was this violation? Or
This actually
incident?
occurred on Sunday morning as they were leaving for Saturday night.
Okay, so this would have been a 3 a.m.
Yes,
close.
sir. Yes.
Now, on the footage that you observed, where you said people were looking and ducking inside of the club, what time was that? Can you
That
tell
was
us?
that was around 3 a.m. 3:10. I can show you the footage.
Okay, well, before you show me anything, I would just like to ask you this.
Okay.
Normally, when a CR or any other place that has an endorsement, isn't the establishment supposed to be clear of patrons and drinks at 3 a.m. and not after 3 a.m.?
Yes, sir. Now, it is shown that security is at the front door getting the patrons out. I would say at about 3:05. They're, trying to push them out the door, and these patrons are like seen, I don't know if they're waiting on Ubers or their ride, but they're seen standing in front of the establishment.
Uber.
Okay, what the question I'm trying to ask is, when you looked at the footage
Yes, sir.
and you testified people were ducking and then eventually they hit the floor,
Yes, sir.
what time on the camera was that?
That was at 3:18.
So would I be stretching it at all to say it's a violation to have people in your club after 3 a.m. that
That's
they should have had a last call prior to maybe 2:45 or something and get all of the people out so that they aren't still inside possibly consuming or still ordering drinks after 3 a.m.?
Correct.
Is that a violation?
Yes, sir.
So you said in your testimony there was no violations, Arbor Out violations found, but after looking at the footage, and you said now that 3:18 people were still inside ducking and whatever else, shooting going outside. So that was a violation, correct? Or was it
Yes,
not?
sir. Yes, sir. It was a violation, but in my experience, I'm told that we at least give them a 10-minute grace period to get everyone out. And yes, sir, this is beyond the 10-minute grace period. If so, it would have been at 3:10, right when this occurred. I did see people still standing around at 3:18. However, I did not see them still coming out at 3:18. When the shooting occurred, the door was unlocked and they were able to kind of like run back in for coverage. But yeah, so yes, sir.
So the door wasn't locked at 3:18. People were still coming and going at 3:18.
So there was a security guard located outside of the door, and there was a security guard, the head security, located inside of the door. So I can say that the door was probably open so that the security located outside was able to get back in once he, was finished outside. However, what I did see was that after the shooting, people were able to run back inside. They grabbed the door. They were like, crowded by the door, trying to run for safety. And a few people were able to actually get back inside, including the security guards ran back inside.
Okay, you said you have the footage now, correct?
Yes, sir.
Did you observe the footage on the inside at 3:18?
Hold on one second, sir.
Thank you.
Am I allowed to talk while she's doing that?
Wait,
Hold on, Mr. Ali.
wait a minute.
There's a miscommunication happening.
Mr. Ali, hold on.
Hold on, Mr. Ali. I'm going to ask some questions too, but we'll have your attorney, if there's some miscommunication, address that issue. Are you ready, Ms. Peterson, to respond to what Mr. Short was asking?
Can I get a few moments? Just a few moments.
Right, fine.
The latest I see, folks walking out is about 3:08. 3:08 a.m.
So after 3:08, the door was still open so people could come and go. I mean, you're saying at 3:08, the security person was standing at the door, but the door was not locked.
No, people were still walking out at that time. At 3:08, they were still walking out. Yes, sir.
So do you have any idea when the last person left that venue at that incident, the night of the incident?
Hold on, please. It looks like the last person left at about 3:25.
So even with the grace period, they were in violation.
Yes, sir. And to be honest, I can't tell if that was maybe a bartender leaving out. I just know it was someone still leaving out at that time. I know it wasn't security because I saw what they were wearing.
So could I surmise that the grace period is that citywide? They're giving 10, 15 minutes after closing to still be getting people out? Is that citywide or is that just this particular event?
No, sir, it's citywide. We give them at least 10 minutes to get out.
Okay, so what time is their last call? Did you check?
No, it appeared to me from looking at the camera footage, it looked like their last call was at 3. Because no one is like people are standing by the bar, but they're not facing the bar. They're actually, leaving out.
I understand that, but as far as you understand the regulations that say they close at 3,
Yes, sir.
even with a grace period,
Right.
there shouldn't have been people there at 3:18.
Absolutely not. I agree.
Well, do you or any other the investigators enforce that, or is that something that's unenforceable?
No, sir, we enforce it. We do after-hour checks to make sure we go around. Of course, I'm on the night shift. We go around and we monitor to make sure these establishments are closing when they're supposed to be. We are, making sure we see people exiting out of the establishment at the appropriate time. Again, like I said, I was told that we are to at least give them a 10-minute grace period of time. But beyond that, no, they're in violation at that point.
Thank you, Ms. Peterson. So again,
You're
if you
welcome.
come before us again and someone is and you should happen to be an investigator on duty, you're on the orange team, is that correct?
Yes, sir.
So anybody on the orange team that would go to a location that has whether they have endorsement or don't have endorsement, if their hours say they're supposed to be shut and closed at 3 a.m. So after 3:10 a.m., I mean, you're giving them a grace period, and they still have people coming, going, or able to go back in if there's something happens outside. Is that following the rules, or is that just I'm just trying to find out generally what is your practice, or what is Orange Team's practice when it comes to last call and getting people out and having the door locked and sealed so that the establishment would appear to be closed to anyone on the street or who had been in the club that evening?
Now, what I will say, Mr. Short, is that although we have a grace period of time, we do make sure and check that the door is locked. However, of course, I was not there that night that this occurred, but that is one of the procedures. The door must be locked. In a grace period of time, people are still coming out within 10 minutes, but no one should be able to come back in. And as I expressed before, yes, they were able to go back in because patrons were able to run back in there for safety. The door was not locked.
Thank you. That's all I have, Mr. Chair. Thank you very much, investigator. Thank
You're
you.
welcome, sir.
Ms. Giannis, on behalf of your client, is there a response?
There is. I know my client wants to speak. And before he does before I ask questions of him. I do want to explain, I think most importantly, the camera footage, and there is a 10-minute delay in the footage. And I will start by saying, I'll have my client talk about the delay, but there's a 10-minute delay in the footage. And even from hearing from the investigator, where the investigator says at 3:18, she saw people, I think, on the floor, if I heard her correctly. If you say there's that 10-minute delay, that corresponds with the, shooting occurring at 3:09. And so I think 3:08 is where she indicated the last patron, initially indicated the last patron left the establishment. That would mean that it would, it's 2:58 a.m. Additionally, there are people that are coming in and out, or there's people that are going out or in or by the door who are actual employees. I will have, if Mr. Ali, can you talk about the 10-minute delay and explain that to the board?
Yes. Oh my God, it was so hard just
explain the 10-minute delay.
It was so hard hearing everything, like, because I see questions going the wrong way, and I wanted to say something to save the conversation. One thing, yes, it is the 10-minute delay that I wanted to talk about. The police officers can verify our cameras are 10 minutes in advance. And two, when you guys see the people ducking, they're not ducking.
Sorry, I kept saying delay.
They're not ducking inside the establishment. They're ducking outside the establishment. But because we do have the glass windows, obviously the inside camera, you can catch it happening from the inside camera going out. But investigator Ms. Peterson can also verify these people are ducking outside of the establishment, not inside of the establishment. And from what I understood, the little delay of people ducking after the shooting went on is because the shooting did not happen literally outside of our door. It was kind of like down the street. As she stated, these two people were hugging and walking out, and then whatever happened once they left our camera, the vicinity of the venue, down the street, only God knows. And we're glad that the guy is okay, but nobody was saw ducking inside the establishment, because a lot of our employees even thought that people were joking about the shooting because you couldn't hear nothing from within the establishment. So that's one thing that I like to correct. No one was ducking inside our establishment.
Okay, just to go back though, to clarify, in terms of your footage being, and I think you said MPD was aware of that it was 10 minutes ahead.
100%.
100%. Can you provide information, or you could provide information that shows that? Is that correct?
Yes, I mean, all we have, I think Miss Peterson, I know it's been a while. I don't know if she's forgotten, but our videos are 10 minutes behind. But you can talk to everyone that ever came into our establishment to look at the videos and take a copy. Everyone can verify that our videos are 10 minutes advanced.
Thank you.
I'm sorry, can you explain what you mean 10 minutes advance? Explain that, please.
Meaning on our videos, when it's 3:09, it's really 3 o'clock. When it's 3 o'clock, it's really 2:51. We cooperate. We do everything we can to make sure that we comply, and we do comply. And the conversation that was just had the past 10 minutes and all the questions that were asked, I know this thing happened 3 months ago, and not everyone really remembers exactly how it happened, but we comply.
Thank you.
And our last call is at 2:30 on the first floor. We turn the lights on at 2:30 because we let people out on the first floor first, and then we get people out on the second floor at 2:45. So by 3, we understand that everyone has to be outside of the building. If you do see people leaving later on, it's busboys leaving because they're done with their shifts. It's employees leaving because they're done, they're cashed out. It's our employees leaving. We do have over 30 employees that work any particular day. So if you guys see people leaving at the end, it's people literally just cashing out and leaving at the end of their shift. So by 3 o'clock, we get all our customers out. We try to do that as much as possible.
Thank you.
Any other questions from anyone? Ms. Peterson, do you have any final comments you wish to make?
No, thank you.
Lieutenant Anderson, any final comments you want to make?
Yes, actually, after the initial, and it may have been a communication mishap with the obtaining the video in the initial scene, our detectives did receive full cooperation from the club as far as the investigation, unfolding. And Detective McLaughlin also wanted, when I spoke to him about the investigation, indicated that Focus DC has been very, very helpful in other investigations and cooperated with MPD and has a good relationship with our officers. Aside from this one little blip on this particular night, which may have been a communication error or something else, but overall, our detectives do appreciate the management of the establishment very much for helping with other events.
Thank
you, Lieutenant.
Thank you, Lieutenant. Mr. Yonis, I'm not sure if you want to say anything else, but I think that detective kind of butted away. You have the last word.
That was more than enough. Thank you, Lieutenant. I just ask that the board consider all of this and take no further action.
Thank you. All right. We'll take this matter under advisement. Thank you very much, Lieutenant, for your appearance this morning. Ms. Peterson and Mr. Ali and Ms. Yon. So, Mr. Ali, one of the things that you stated that you're a new owner. I'm not sure if you're aware that we do have, the agency does have training for new owners, and I would ask that you look into whatever training the agency offers for new owners, and so that would bring you up to speed on just to assist you in the operation of your business, sir. It's something that's available to all new owners, and I would implore you to investigate that, sir.
Would love to. Thank you.
Thank you. Have a great day, and thank everyone for their appearance today. Thank you. The next case on our calendar is a show cause hearing, case number 21 CC 00031, New Dodge Market, license number 99565. Ms. Foshman, can you please elevate the rights of the licensee and the witnesses in this case, please?
Please stand by. I do not see the licensee in the room. James Jordan, your rights have been elevated. I don't see Adam Murray in the room. Kevin Puente, your rights have been elevated. And George Garcia, your rights have been elevated. That is all, Mr. Chair.
Thank you. Good morning, Mr. Jordan. Mr. Jordan, have you had any contact with this licensee?
Not recently, Mr. Chairperson. We have had email contact in the past since the status hearing, but nothing since this matter was continued.
All right, let me have the parties introduce themselves for the record. We'll start with you, Mr. Jordan.
Good afternoon, Mr. Chairperson. James Jordan on behalf of the district. That's James Jordan.
And who's with you this morning, sir?
With me are investigators Kevin Puente and George Garcia.
This matter was scheduled for a show cause hearing, and I see that before I'm trying to see whether or not the licensee is online, and if the licensee is anywhere online, can you please identify yourself through the chat for us to make a determination if you're here. This matter was scheduled for the show cause hearing at 10:30 a.m. It is now 12 noon, and so I'm not sure if the person was online at any point this morning, but we'll just wait a couple more minutes to see if the individual identifies themselves on the chat for us to begin.
Chairperson, I see a raised hand. Emma Bet, I'm going to unmute you. Are you part of this case?
Yes, yes, sir.
Yes.
Okay.
All right, thank you. I'm glad that we do that. Yes. Do you have a camera? I can hear you. Do you have a camera?
Yes.
He won't let me do it.
I think I cannot do it. I don't know how.
It's not let me, yeah, it's not let her turn on.
Ms. Fossman, have you elevated their rights for them to, have you elevated their rights as for the camera? I'm not sure. Is it something internal?
Their rights have been elevated.
It's disabled. You can't.
It's disabled. When I touch it, it's not working.
We have elevated your rights for you to turn your camera on, so I'm trying to find out if it's something internal on your part. Have you tried to turn your camera on and it does not come on?
Yeah.
Yes, I'm trying, but it's not coming on.
Still has it.
All right, it's fine. All right.
It has a red light, a red arrow thing.
It has a red arrow?
On the camera.
On the camera.
I'm told from the agency's perspective that they have elevated your rights for you to turn your camera on. So it's probably just an error. I'm not an error, the technical issue on your part, but we can move forward with, well, let me ask you, well, we'll move forward as long, I mean, I can hear you. And so we can move forward. So, all right, so this case is New Dodge Market. So let me have the parties introduce themselves again for the record. So let's start over again. Mr. Jordan, can you introduce yourself for the record, please?
Yes, Mr. Chairperson, James Jordan on behalf of the District of Columbia. That's
Good morning, Mr. Jordan.
JAMES, JORDA.
All right. Who's the licensee in this case? Can you please spell and state your name for the record, please?
Mebet, EMEBET, last name Habtemariam, HABTEMARIAM, Habtemariam.
Good morning. And what's your relationship to this establishment, Ms. Habtemariam?
I'm the owner.
Okay, thank you very much. I hear someone else in the background, and I only need to have one person speak. You're the owner. Unless that person is a witness, they should not be speaking for this hearing. All right.
Okay, sir.
Mr. Jordan, this is a show cause hearing. Are there any preliminary matters in this case?
No, Mr. Chairperson, no preliminary matters at this time.
And are you, all right, Ms. Habtemariam?
Yes.
If you're not speaking, can you please mute your microphone, please?
Sure.
All right. This is a show cause hearing, meaning that the government will call witnesses to see whether or not they can substantiate this matter. So the way we'll begin, the government will do an opening statement. The licensee will also have an opportunity to have an opening statement. Once both parties have done an opening statement, the government will call its witnesses. The licensee will have an opportunity to cross-examine the witness. Once the government has presented its case, then the licensee will present its case. Ms. Haptamarin, do you have any questions on how this matter is moving forward?
No.
All right. And so at the beginning, so now the government, does the government wish to make an opening statement?
Yes, Mr. Chairperson.
All right, go ahead, sir.
Good afternoon, Mr. Chairperson and board members. We are here today in the show cause matter of HSR Incorporated trading as New Dodge Market. The show cause notice in this matter concerns the charge that the licensee sold alcohol to a minor in violation of DC Code Section 25-781. The facts will establish that on August 22nd, 2021, ABRA investigators Kevin Puente and George Garcia visited the establishment with an undercover minor and established that a sale to minor occurred. You will hear from Investigator Puente that at approximately 5 p.m., he met with the undercover minor and ensured that the minor's identification clearly stated the date of birth, January 2001. At the time of the compliance checks, the minor was 20 years old. Investigator Puente then accompanied the minor on these compliance checks, keeping a watchful eye on the actions of establishment staff. At New Dodge Market, the minor entered, picked up a can of Twisted Hard iced tea, and approached the cashier. In view of the undercover Investigator Puente, the cashier proceeded to sell alcohol to the minor. Investigator Puente and the minor left the establishment, and the minor turned over the Twisted Hard tea to Puente. Investigator George Garcia then entered the establishment. He identified himself as an ABRA investigator and informed the ABC manager of the violation. The manager then signed a sale to minor notification form. At the end of this hearing, the district requests the board apply a penalty consistent with DC Code Section 25-830. Thank you.
Ms. Haptamarin, do you wish to make an opening statement now, or do you wish to make that statement once you present your case?
I will do it now.
And an opening statement is just, you're going to tell us, okay, go ahead, ma'am.
Okay, sir. Dear board members, as you know, most small business in DC area are struggling to find and to keep experienced employees because of employing getting sick of COVID and employee turnover. Because of mentioned reason, I am forced to hire inexperienced employees. Unfortunately, ABC manager who sold to minor just started only 1 week ago. I am appealing the board to consider the above issue, asking to give me abatement for the violation. Thank you.
All right, so I guess the issue then, where we are in this case, so are you then stating, ma'am, that the sale did occur? Are you admitting that the sale did occur?
Yes.
And so, well, if there's an agreement that the sale occur, then we don't necessarily need to have hearing. I mean, we don't need to take testimony on the underlying violation. It appears that where we are now is that it's the penalty stage of it. Because from what I'm hearing, the licensee is asking for abatement, is asking the board to abate the fine. Is that what you are asking, ma'am?
Yes.
Now, Mr. Jordan, I believe that we can dispense with the presentation of witnesses because the licensee has basically admitted that the sale has occurred. And so one of the things that we can do is, why don't we then move towards the penalty phase? Where are we? What is the violation? What is the violation? What it is that you are asking the board to do based on the violation? And then I'll have the licensee once again state yes, that they agree that there's a violation, and and the type of penalty that they ask, if any, that they're asking the board to impose. Is there agreement between the parties on that issue?
Yeah, yes, Mr. Chairperson.
Ms. Haptamarian, do you agree with that, ma'am?
Yes.
All right. Okay, so Mr. Jordan, so we don't need then the witnesses to testify because the licensee has agreed that the sale to minor did occur. So there is the violation did occur. So we're just going to take testimony on what penalty, if any, the board should impose based on this violation. And so therefore, Mr. Jordan, I can have you just for the record to state what the penalty, what the violation is and what penalty is being recommended by the agency, by the government that the board should consider.
Yes, Mr. Chairperson. The violation here is a sale to minor in violation of DC Code Section 25-781. This is the second sale to minor this establishment has been found in violation of within the last 2 years. The district is recommending a penalty more in line with DC Code Section 25-781F2, which is a $2,000 minimum fine.
Now, are there any, I guess based on this, if the board was with this violation, are you aware, are there any triggers, or are there any other penalties, if any, that were triggered based on this, if based on this now violation?
Yes, Mr. Chairperson. A prior offer and compromise with suspension days stayed was triggered. That was 4 suspension days from, and I can provide the case number if the.
What's that, sir?
Yes, that is. Board's indulgence. That is case number 20CC00065.
Okay. And what's the date of this, please?
That the date of the offense was July 30th, 2020. A staff settlement occurred November 4th, 2020.
November what date? I'm sorry.
Yes, November 4th, 2020.
And when did this violation occur?
The instant violation, Mr. Chairperson?
Yes, yes.
Yes. That was August 22nd, 2021.
Thank you. All right, thank you, sir. Ms. Haptanarian, now you heard that you have admitted to the violation occurring and that the sale to minor did occur. So what is it that you're asking the board then to do based on the fact that you are agreeing to the violation?
I'm asking about the to reduce penalty. You know, the suspicion. I'm a mother with 3 kids, and you know I cannot stay there every time. But everyone who I hire, I explain, I show them how to do. But you know, for example, the guy look the driver license, but the ID, even he check it, still he make mistakes. So people make mistake, but you know, just to reduce the penalty, I'm asking. It's been hard for me also.
So you're asking us to reduce the penalty, and
Yes.
you're asking us to reduce the penalty. Are you aware that because this other violation occurred less than 1 year after previous violation, that there are other penalties that are going to be imposed based on that previous violation?
Yes, sir. But you know, I even have a BC manager every time, every shift, but I don't know how, but they make mistake.
Okay, ma'am. So basically, all you're asking us to do is to reduce the penalty. Is that so? You're saying that you're guilty, and you're asking the board to reduce the penalty. And again, why is it you're asking the
The
board to reduce
suspension
the
also.
penalty? I'm sorry.
The suspension also, the penalty and the suspension.
So you're asking the board to reduce the penalty and the suspension. And why should the board reduce the penalty and the suspension, ma'am?
You know, as a small business, I'm struggling to stay open for, and it's been a lot of issue. It's not only ABC manager issue. Still, I have a lot of issues. So I want the board to consider my situation.
And what type of establishment do you own, ma'am?
A small business.
No, I'm sorry. Are you a liquor store? Are you a liquor store? Are you a grocery? What type of business do you have, ma'am?
It's like a grocery.
And what type of license do you have for this grocery, ma'am?
What do you mean? A grocery store license.
Okay, all right. You have anything else you need to say, ma'am?
No,
Okay, thank you.
thank you.
Okay, all right. As chairperson of the Alcohol and Beverage Control Board for the District of Columbia, in accordance with DC Official Code Section 2574B of the Open Meetings Act, I move that the ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 21CC 00031 New Dodge Market, pursuant to DC Official Code Section 2574B4 of the Open Meetings Act, and deliberating upon case number 21CC 00031 New Dodge Market for the reasons cited in DC Official Code Section 2574B13 of the Open Meetings Act. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed 6-0, I hereby take notice that the ABC Board will recess its proceedings to hold a closed meeting in the ABC Board Conference Room pursuant to Section 2574B of the Open Meetings Act. Thank you, Mr. Jordan. Thank you, Ms. Habtemarian. The board will take the recommendations of the government under consideration. The board will also take the recommendation of the licensee under consideration, and we will issue an order accordingly. Thank you very much and have a great day.
Thank you so much. Have a nice day.
Thank you. Bye then. Bye-bye.
Bye.
The next case in our calendar is case number 21 CMP 00054, Mirror Lounge, license number 111950. This case has been canceled. An OIC was submitted. I'm sorry. This hearing has been canceled. The parties offered an offer in compromise to the board that the board will consider on its legal agenda. So we're now at the end of our morning's calendar. And since we're at the end of our morning's calendar, I will now do our legal agenda. The first matter on our legal agenda is the review of an offer in compromise in lieu of a hearing date on March 22nd, 2022 for case number 2022 CMP 00005 DC Food Market, license number 106962. And the offer in compromise is that charge one, extend hours of operation without approval, statutory authority, DC Code Section 25762. The 13, the fine, there will be a fine of $2,000 payable within 120 days of the board accepting the offer in compromise, and if payment is not made within 120 days, the license will be suspended until payment has been made. For charge number 2, no owner or ABC manager present on premises during hours of sales, service, and consumption of alcohol. Statutory authority 23 DCMR section 707.1. The fine is a fine of $2,000 payable within 120 days of the board accepting the OIC. If payment is not made within 120 days, the license will be suspended until payment is made. And charge number 3, failure to follow the terms of the license by extending hours of operation. Statutory authority DC Code section 25823A7. This charge has been dismissed. I therefore make a motion that the ABC board accepts this offer in compromise. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 6-0. Number 2 on our legal agenda, review of the offer in compromise in lieu of a hearing date of March 21st, 2022 for case number 21 CMP 00054, case number 21 CMP 00070, case number 21 CMP 00072, case number 22 CMP 00001, and case number 22 CMP 00003. This is the Mirror Lounge license number 111950. And the offer in compromise is as follows. For case number 21 CMP 00054, charge 1, allowed music to emanate from the establishment at such intensity that it may be heard inside of a nearby residence. Statutory authority DC Code section 25725A. There's a fine of $500 payable within 120 days, or the license shall be suspended indefinitely until the fine has been paid. For case number 21 CMP 00070, charge 1, allow music to emanate from the establishment of such intensity that it may be heard inside of a nearby residence. Statutory authority DC Code section 25725A. The fine is a $500 fine payable within 120 days, or the license shall be suspended indefinitely until the fine has been paid. For case number 21 CMP 00072, charge 1, allow music to emanate from the establishment of such intensity that it may be heard inside of a nearby residence. Statutory authority DC Code section 25725A. A warning will be issued for this case. For case number 22 CMP 00001, charge 1, allow music to emanate from the establishment at such intensity that it may be heard inside of a nearby residence. Statutory authority DC Code section 25725A. This charge has been dismissed. And for case number 22 CMP 00003, charge 1, allow music to emanate from the establishment at such intensity that it may be heard inside a nearby residence. Statutory authority DC Code section 25725A. This case is also dismissed. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 6-0. Number 3, review of the request to reinstate canceled license dated March 18th, 2022. License was canceled on November 18th, 2020 pursuant to board order number 2020-740. This is for Hellbender Brewing Company, license number 093500. I make a motion that we deny this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 4, review of request to reinstate canceled license dated March 21st, 2022. The license was canceled on November 17th, 2021 pursuant to Board Order Number 2021-802. This is for Luna Grill and Diner, DC, license number 102955. I make a motion that we approve this request. Is there a second?
Bobby Cato seconds.
Mr. Cato seconds the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 5, review of request for hearing dated March 18th, 2022 on Board Order Number 2022-088. This is a cease and desist issued to an unlicensed establishment located at 1400 North Capitol Street Northwest. I make a motion that we grant this request. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 6, review of settlement agreement dated February 8th, 2022 between Advisory Neighborhood Commission 6B and Zoka and Crush by Zoka, license number 119693. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passes 6-0. We now move to our licensing agenda. The first matter on our licensing agenda is a review application for safekeeping of license. This is for Capital Crab and Seafood, license number 106151. I make a motion that we approve this request until September 30th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 2, review application for safekeeping of license. This is for District Still, license number 102521. I make a motion that we approve this request through September 30th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 3, review of application to extend safekeeping of license. This is for Equinox Sports Club, license number 096730. I make a motion that we approve this request through September 30th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 4, review letter of request to expand operations to the 2nd floor and increase the total occupancy load of the establishment from 57 to 87. This is for Chair Ethiopian Restaurant and Mart, license number 090311. I make a motion that we placard this matter. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. We now move to our supplemental license agenda. The first matter on our supplemental license agenda is a review request to remove license from safekeeping to reopen new business. This is for Georgetown Wing Company, license number 119851. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 2, review request for an off-premises storage permit endorsement to store unopened alcoholic beverage inventory off-site at 500 Emerson Street Northeast. This is for Dummies Q, license number 109538. Excuse me, I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 3, review application for an off-premises storage permit to store additional unopened alcoholic beverage inventory in an additional unit of the same building at 645 Taylor Street Northeast, Unit 1001. This is from Panifer Trading, license number 114093. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. Number 4, review application for transfer of ownership of license. This is for Columbia Care, license number 117373. I make a motion that we refer this back to licensing. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. We now move to our cancellation agenda. The ABC Board will be canceling the following license for the reasons outlined below. Fine Vine, license number 075977. The licensee requests cancellation. The Alibi, license number 097969. The licensee is out of business. I therefore make a motion that the ABC Board cancel both licenses. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. We now move to our board temporary one-day substantial change docket. I'm going to read the first 15 requests from licensees in the record. Once I've read all 15 names, the first 15 names, I will state the category and what's been requested in the date and the date and the license, and I'll make a motion that the board approve the first 15 requests. So the first request, a request made by Cara Lombardi. This is for one-day license class F. This is a wedding on June 19th, 2022. The license number is 120855 for 95 attendees. The second request, a request made by Stephanie Sims a one-day license Class F. This is a wedding on April 13, 2022. The license number is 120866, 60 attendees to a security guard. The third request, a request made by Amelia Neptune for one-day license Class F. This is for a reception for the League of American Bicycles. This is on March 30th, 2022. The license number is 120862. This is 100 attendees, 2 security guards. Number 4 is a request from Adriana Baddick, a one-day license Class G. This is a fundraiser for Thomas Circle Singers. This is on April 30th, 2022. The license number is 120826, 100 attendees, 3 security guards / volunteers. Number 5 is a request from Steve Bilidath, a one-day license Class G. This is for a reception for Axios Media. This is April 4th through April 5th. The license number is 120828, and the attendees up to 300 attendees and 6 security guards. Number 6, a request from Jonathan Reef, a one-day license Class G. This is a fundraiser for the Merch PTA. This is on April 23rd, 2022. The license number is 120827, 300 attendees, 6 security guards. Number 7 is a request from Matthias Galicia, a one-day license Class G. This is a wedding on May 6, 2022. The license number is 120851, 125 attendees, 3 security guards. Number 8 is a request from Miles Peters, a one-day license Class G. This is a wedding on April 2nd, 2022. The license number is 120863, 125 attendees, 3 security guards. Number 9, a request from Maria Murphy, a one-day license Class G. This is a reception at the Whitfield Entertainment Group Studios, Inc. This is for March 28th and March 29th, 2022. The license number is 120880, 19 attendees, 38 security guards. Number 10, a request from Studio 52 Miss X LLC, a one-day substantial change. They're requesting a one-day substantial change to extend hours from 2 a.m. to 3 a.m. This is on April 2nd, 2022. The license number is 115069. The substantial change license number is 22 SC 00578. Number 11 is a request from the Army and Navy Club, a one-day substantial change. It's a one-day substantial change to use license off premises on 12th floor of the same building. This is on May 18th, 2022. The license number is 000114. Substantial change numbers, license numbers 22 SC 00579. Number 12, another request from the Army and Navy Club, one-day substantial change. They're requesting a one-day substantial change to use a license off premises on the 12th floor of the same building. This is on June 15th, 2022. The license number is 000114. The substantial change license number is 22 SC 00580. Number 13, another request from the Army and Navy Club, a one-day substantial change. It's a one-day substantial change to use the license off premises on the 12th floor of the same building. This is on July 20th, 2022. The license number is 000114. The substantial change license number is 22 SC 00581. Number 14, another request from the Army and Navy Club for one-day substantial change. The one-day substantial change to use the license off premises on the 12th floor of the same building. This is on August 17th, 2022. The license number is 000114. The substantial change license number is 22 SC 00582. Number 15, another request from the Army and Navy Club for one-day substantial change. The one-day substantial change to use the license off premises is on the 12th floor of the same building. This is on September 21st, 2022. The license number is 000114. Substantial change license number is 22 SC 00583. I therefore make a motion that ABC Board grants the request in the 15 establishments that were license application that were just read in the record. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
and Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 6-0. We have 3 more requests on our one-day substantial change license. And these are 3 bar crawls made by the Good Bar Crawl. I'm going to make a motion that the ABC board grants the pub crawl with an approval of 950 participants. The first, so that's what the motion is. I'll read the 3 bar crawls, and at the end of that's the recommendation, and then we'll vote on the 3 bar crawls. The first bar crawl, the Good Bar Crawl, is a pub crawl. They're requesting 950 attendees. This is the brunch crawl. This is on July 30th, 2022. The license number is 1121754. The substantial change number is 22SC00574. They're asking for bar crawl on the U Street corridor begin at 9th and U Street up to U Street at 14th and U. The second, number 17, is another bar crawl from the Good Bar Crawl. Again, a pub crawl requested 950 participants. This is for the Joff Crawl. This is on September 17th, 2022. The license number is 112754. The substantial change number is 22FC00573. Again, this is on the U Street corridor. And number 18, another pub crawl from Good Bar Crawl. Again, they're asking for 950. This is the Henny Crawl. This is on November 12, 2022. The license number is 112754. The substantial change is 22SC00575. Again, it's a pub crawl on the U Street corridor. I make a motion that the ABC board approve these pub crawls for 950 participants. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, because of public safety and the numbers of people on U Street, I don't think will be supported by the city. I vote to deny 16 for 950. I vote to deny number 17 for 950. And I vote for number 18 to deny because of 950 people on U Street. I vote to deny. Thank you, Mr. Chair.
Thank you, Mr. Short. Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis agrees with the motion.
And Mr. Anderson, I agree. The matter passed 5-1. Thank you. We now move to our license administrative docket. On our license administrative docket, there are 13 applicants. I'll read the name of the 13 applicants, the class category, and what's been requested at the end of the list. I will ask that ABC board approve these applications. So the first request is a request made from Cranes, license number 112800. They are a retailer C restaurant. They're asking for carryout and delivery application. Number 2 is a request from Wags Shaw's, license number 101707. They're a retailer C restaurant. This is a trade name change application. The new name is Wagshaw's / Chef Trini's. Number 3 is a request from Delena license number 117926, their Retailer C Restaurant. This is a letter of request to expand the Sidewalk Cafe from 45 seats to 80 seats. Number 4 is a request from Michael David Farrar. Michael David Farrar. This is for personal importation permit application. The license number is 22 IMP 00006. Number 5 is a request from Absolute Thai Restaurant, license number 082154, their Retailer C Restaurant, a stock transfer application. Number 6, a request from Rodman's Discount Spirits, license number 120765, their Retailer A Retailer A license. This is a transfer with sale application. Number 7, it's a request from the Fairmont, Washington, D.C., license number 060618, Retailer C Hotel, change of office application. William A. Webster is now Vice President. Number 8, a request from St. Gregory Luxury Hotel and Suites, St. Greg Kitchen and Bar, license number 116478, Retailer C Hotel, letter of removal of licensee from application. We're now removing Independent Restaurant Group LLC. Number 9, it's a request from Irregardless, license number 120265, Retailer C Restaurant, transfer with sale application. Number 10, Sierra, they are license number 113445, their Retailer C Restaurant, letter of request to remove Officer Jorge Sosa Vargas. Number 11, Wine and Organic, license number 120238, Retailer B Beer and Wine, new ABC license application. Number 12, the Avalon Theater, Retailer CX Multipurpose Facility, letter of request to remove officers Deborah Zogazinski and Susan Linsky. Number 13, 116 Club, license number 000892. Their Retailer CX Club, change of officer application to add William G. Simpson as secretary. I therefore make a motion that ABC Board grants these requests. Is there a second?
Mr. Short, I second.
Mr. Short accepted the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Mr. Grandis.
Edward Grandis, I agree.
I'm sorry.
Edward Grandis, I agree.
Yes, Mr. Grandis. Ms. Crockett.
Rafi Crockett, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
And Mr. Anderson agree. The matter passed 6-0. We're now at the end of our morning agenda and morning calendar and morning agenda. The board will be in recess until approximately 1:30 for us to come back to our public session. I will ask that all board members return to executive session so we can make a determination on what time we'll come back to our public session. So I'll ask all board members to return to executive session briefly. Have a good morning. Thank you. We're on the record. Good afternoon, everyone, and welcome to the afternoon session of the ABC Board. My name is Donovan Anderson. I'm chairman of the ABC Board. We have five other members with us this afternoon. The five members are Mr. James Short, Ms. Rafi Crockett, Mr. Bobby Cato, Ms. Jenny Henson, and Mr. Edward Grandis. The board has 6 members for the conduct of business, and that constitutes a quorum. Before we get underway with this afternoon's calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 4 cases scheduled for this afternoon. Once the case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all camera and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. All right, our first case on this afternoon's schedule, it's a fact finding hearing on case number 21-251-00038. The Shoreham Hotel license number 13816. This case has been continued to March 30th, 2021 at 10:30 a.m. The next case on our calendar is case number 22-251-00007. This is Cloud Restaurant and Lounge Sports Bar license number 93572. This is a summary suspension hearing request. Ms. Washburn, can you please elevate the rights of the parties in this case, please?
Please stand by. Richard Bianco, your rights have been elevated. Anthony Cello, your rights have been elevated. To Vril Prout, your rights have been elevated. That is all, Mr. Chair.
Good afternoon. Thank you very much.
Good afternoon, Mr. Chair.
Good afternoon, Mr. Cello. Can you please spell and state your name for the record, please?
Anthony Cello, ANTHONYCELO, Assistant Attorney General on behalf of the government.
Good afternoon, Mr. Cello. Mr. Bianco.
Richard Bianco, last name is Bianco, counsel for the respondent.
Good afternoon, Mr. Bianco. Is your is your client going to be here this afternoon, sir?
No, sir.
All right, fine. This matter was scheduled, it's a summary suspension hearing that the chief of police, it's my understanding the chief of police had closed this establishment down for 96 hours. The ABC board voted to extend the closure, and by operation of law, the licensee had requested a hearing. This hearing was granted within the statutory timeline. So we are here for this hearing pursuant to statute. And so, Mr. Cello, where are we? Are there any preliminary matters in this case?
Yes, Mr. Chair. The parties are in negotiations. It does look like we will be able to resolve this matter. We have not yet resolved it. And speaking on behalf of Attorney Bianco, we are requesting a 1-week continuance of this matter to allow for a resolution through negotiation.
Thank you, Mr. Bianco. Is that, as you're aware, this is your client had requested this hearing. We had complied, the board complied with the statutory requirement for us to have this hearing within the 2 days, I believe, after the request was made. And it's now my understanding that a continuance has been requested. Is this a joint continuance on your part, sir?
Yes, it is. That's accurate. We filed a request, I believe, at some point on Monday, and we thank the board for acting quickly, scheduling it for today. I think that's probably what prompted us to enter into more serious settlement discussions, and it looks like we'll be able to get this resolved within the next week. And that's certainly my hope.
And is the client aware that the suspension will remain in effect until there is an order or there's an agreement on the part of the government until an agreement has been reached to lift the suspension on preventing them from selling or serving alcohol. Is your client aware of that?
Yes, they are. And as of last night during my investigation, the placards indicating an indefinite suspension until order of the board are still posted on the front of the establishment, and they will remain so.
I know that the placards are posted. I just want to make sure that your client is aware that they are unable to sell or serve alcohol during. I know that the agency has done its part in posting the red placards, or I'm sorry, not the red placards, the placards on the establishment. I want to make sure that the licensee is aware of what the placards mean, that the licensee is aware that they cannot sell and serve alcohol until this board has lifted those orders. I just want to make sure that your client is aware.
They have been so advised and indicated their understanding of the instruction.
All right, thank you. Thank you for that representation, Mr. Bianco. All right, with that said, this matter then is continued for further hearing on March 30th, 2022 at 1:30 p.m. Thank you very much.
Thank you, Mr. Chair.
All right, the next case in our calendar is case number 21 CMP 00045. This is the Georgetown in West End, Costas Rumbar, license number 109462. Ms. Henson will excuse herself will recuse herself from participating in this case. All right. So, Ms. Foshbon, can you please elevate the rights of the parties in this case, please?
Please stand by. Sidon Johannes, your rights have been elevated. Andrew Scholwolf, your rights have been elevated. Nayan Patel, your rights have been elevated. Please stand by. There's a lot of names. Vanessa Pleites, your rights have been elevated. That is all, Mr. Chair.
Thank you very much. Sorry. All right, I would like the parties to introduce themselves for the record. Let's start with the government, please.
Assistant Attorney General Anthony Cello, Anthony Celo, on behalf of the district. Good afternoon again, Mr. Chairman.
Good afternoon, sir. And I think there are two different attorneys, so let's have the attorney for the, Mr. Johannes, can you please spell and state your name for the record and specifically identify who is it that you represent?
Sidon Johannes on behalf of Wabbit LLC, and that is SIDONYOHANNES.
Mr. Wolf, I know I probably did a horrible job. Can you please spell and state your name for the record and who is your client, sir?
I'm gonna give you a B- on that one. That was pretty good though. Better than most. It's Andrew Scholwolf. I'm gonna spell that last name. S as in Sam, CHULWOLF as in Frank. Counsel for Georgetown Suites LLC.
All right, thank you. And so this matter is scheduled for a show cause hearing, and so are there any preliminary matters in this case, Mr. Cello?
Yes, Mr. Chairman. There is a significant stipulation in this matter, and opposing counsel can correct me if I misstate anything, but my understanding is that the parties will all stipulate to all of the facts contained within the investigative report, except for the specific amount of patrons that was counted. There is a stipulation that it was above the occupancy limit, but not as to the specific number of patrons who were present. All other facts are stipulated as in the investigative report.
And on behalf of Georgetown Suites, I will say to Mr. Chairman that we have no objection to the findings set forth in the investigative report. I think the objection is solely by Wabbit.
Ms. Yonis,
That's correct. Yes.
what's the significance of? I'm just asking. No, not your disagreement. I'm hearing that there's a stipulation that there was the occupancy was above the legal limit. Is that this is what I heard? Is that correct?
That is correct.
So what I'm basically asking, what's the difference? Whether or not it's 1 over or 10 over? What's the difference? I'm just trying to get some clarification because I'm not familiar. I don't know.
I think there are reasons why we decided to stipulate or not to stipulate to that number specifically. But generally, yes, you're correct in that we are stipulating that it is over occupancy.
Okay.
So for purposes of correct to move forward, yes, it is over occupancy. We have no objection to the facts as stated otherwise in the case report.
So, how many charges are, Mr. Fellow? How many charges are in this case?
There are 2 charges. There's a charge of allowing dancing within the establishment without a dancing endorsement, a violation of DC Code 25-113, subsection AB1, and 23 DCMR 1000. There is also a second charge of failing to follow the board-approved license by increasing the occupancy of the establishment in violation of DC Code 25823A7.
Now, do we need to take testimony on the increase in occupancy, or there's agreement, as I said, there's agreement that there was an increase, and I mean, I'm just trying to find out, we can just factually state, do we need to have testimony on that issue? That's what I'm asking from the parties.
Mr. Chair, I would leave that to your discretion. I am prepared to conduct a very short direct examination to outline just the key facts and findings of the report, just for the board's benefit as we go forward. I do understand that there are other facts that are not directly stated in the report, which may be elicited by the other parties. So I'm prepared to conduct a very short direct examination, or if the board feels that's unnecessary, I would abide by that decision as well.
Well, I'm
Usually, I don't believe that we need testimony. I think we've stipulated to, and we've represented that we are fine moving forward. There's 2 charges here in terms of the increased occupancy. We've stipulated there was an increase of occupancy. I don't believe testimony is necessary. I think you, Mr. Chairman, said doesn't matter what the number is.
All right.
I would disagree with that, Your Honor. I mean, that's the notice here, Your Honor. Mr. Chairman, I would disagree with that. It's one thing if it's one person over the limit. It's another thing if you're talking about 250 people, which is significantly higher than the limit. And that really does go to what our issue is and has been with this operator, which is a continual violation of DC code. This particular operator is to put it bluntly, is a menace to both my client surrounding me. Hold on. If I can finish,
you just answer the question.
I promise I won't interrupt counsel if she doesn't interrupt me.
To be honest, I have no idea what is going on in this case, but I'm trying to.
Sure. Apologies.
I'm trying to get some clarification, and I would ask that all parties please allow everyone an opportunity to speak. If there is an objection, because they're all attorneys, I expect the attorneys to raise the objection, and I'll make a ruling on the nature of the objection, and then we will. So if moving forward, if there are objections raised, please raise an objection, and then we will rule on the objection. All right, so go ahead, Mr. Sherwood. Mr.
Yeah, so
Sherwood.
I do think
I don't know what's going on, so I'm just trying to get some clarification before we do this hearing.
Well, I'm happy to give you just a very brief background on what Georgetown Suites' position is with regard to these the violations, including its relationship with Costas, if that would provide some clarification. I think it might be helpful if you give me just a couple of minutes. I'll try to.
No, you're gonna have an opportunity to do an opening statement, so you can do that. What I will do is that I will just ask for in the opening and the presentation, then we can have some brief testimony on the occupancy level. We can have some brief testimony on the occupancy level. We do not need extensive testimony because there's agreement between the parties as far as the board is concerned that a violation occurred. Okay, so because the occupancy, so we can have some brief testimony on that just to clarify the issue for the board. So if it's a matter of, and as you have stated, Mr. Sherwood, if it's 1 or if it's 200, then that, if the board is making a decision as far as penalty, maybe the board will look on whether or not it's 1 person over the occupancy or 100 persons over the occupancy, which would make a difference for us as far as the penalty stage. But I don't think it's necessary for us to have extensive testimony on this issue. And it appears just from what I'm hearing that there is, this is the first case I've had where there's 2 licensees and there's not agreement between the licensees. And so I do not know what the internal argument is between the 2 licensees, but where we are today, this is a hearing on whether or not the licensee permitted dancing without an endorsement and whether or not the licensee increased occupancy. And so as far as the board is concerned, the licensee is either innocent or guilty of the charge. And it's one entity in a sense, although there are 2 attorneys, it's the licensee. So I don't believe that the board can say licensee A is 50% liable and licensee B is 50% or what. It's one licensee in the sense that whenever a decision is made, the board will make a decision to say the licensee is responsible. Whatever fine or fee, whatever fine, the board will state that the licensee will pay this fine, and it's internally the licensee. If the different parties then between themselves, they would have to figure out what it is that they're going to do. But as far as the board is concerned, it's the licensee, and it's one license, and that's the licensee is a person who or the entity that's responsible for if there's an infraction, and internally they can decide, but the board is not going to decide to say one licensee is more liable than the other. I just want to make sure that the parties are clear how it is that the board will make a determination moving forward. Okay. All right.
Very good.
Thank you. So,
if I may, Chairman Anderson,
yes,
I just want to also, just to simplify, we will stipulate to the case report as a whole, and therefore we don't believe there would be a need for any testimony, including occupancy.
And Mr. Sherwood?
Georgetown Suites would like testimony with regard to the penalty phase of this. I think it's important for the board to understand, 1, the relationship between the parties, and to understand and become aware of the complaints from my client, who is the landlord here, the surrounding neighborhood, and also being aware of the fact that there are 6 prior violations by this operator, which is the Costas Rum Bar.
Well, Mr. Feller, this is your case. You have, the government has a burden, and so you decide to, I can't tell you how to, I can make suggestions and I can't tell you how to present your case. So in looking at this case, you present the case that you believe it's appropriate to present it. I think the only agreement that we have is that there is agreement between the parties that the occupancy was increased, so you could provide some testimony on the numbers, but it doesn't have to be extensive. But the rest of it, you present your case there the way you wish to present your case.
Mr. Chair, my understanding of that last assertion was that there was a complete stipulation to the facts of the investigative report. Did I get that wrong, Attorney Johannes?
No, you did not.
But I believe that Mr.
Showolf
is not in agreement with that. He wants, I think I heard.
We're in agreement with the facts set forth in the charge. What we would like the testimony on is in relation to the penalty phase as a result of the violations.
So
we'd like to be heard as far as aggregating factors, which we would like the board to consider when it renders its penalty in connection with these violations.
All right, sir, thank you. Mr. Sello, it's your case. You then have to present your case the way you believe it's appropriate based on the representation made by counsel. But at the same time, enough information needs to be provided to the board, so the board will have enough information in the record. The case report by operation of law is in the record. However, and if we need to read it, the board will read the case report, irrespective of what's made today. But I was just stating that we'll see what it is that what will be placed in the record, what we have testimony on, what will be in the transcript. So if this matter is appealed by any party, then we'll have a clear record of to support whatever decision the board makes, that we'll have a full and complete record to support whatever decision the board makes.
And Mr. Chair, in order to get us rolling on this, may I suggest that we do opening statements? I think I can rest on the report being in the record, and then we can get into any testimony from the from the respondent.
Yes, that's what we'll do. So therefore, the government will have an opportunity to do an opening statement, and then the parties, the respective parties, other parties, they'll do an opening statement, and then we can start the case, the presentation, and the government will decide how it wishes to present its case. All right, so Mr. Fellow, go ahead with your opening statement, please.
Thank you, Mr. Chairman, ladies and gentlemen of the board. May it please the board. The facts in this case are, as we've discovered, not in dispute. This is a situation in which the investigative report does lay out all the facts that the board needs to consider, and that is already part of the record. As this board reads the report, it will learn that this matter came about as a result of a noise complaint at the establishment, that investigator Plietz investigated the noise complaint and was able to identify that the establishment, Costas Rum Bar, was allowing dancing inside the establishment without the appropriate license. Additionally, there were approximately 250 patrons dancing, standing, or otherwise moving about within the inside of the establishment, which was limited to no more than 99 seats. The findings of the investigation are that the license holder is split 50-50 between the landlord, Georgetown's Inn, and the tenant, Costas Rum Bar. However, the government would agree with the board's pretrial assertion that there is a single license holder for the purposes of this evaluation. The findings are also not in dispute. There was dancing without an endorsement, and there was over occupancy, significant over occupancy of 250 patrons. We believe that a fine is appropriate. However, I do understand that there will be a request for a more severe penalty, and do not anticipate that we will object to whatever penalty the board deems appropriate, so long as it is at minimum a fine appropriate for the level of violation and the history, which is also on the record already. Thank you.
Thank you. Ms. Yonis.
Yes. So the facts here are not in dispute and that we've already stipulated to them. You may be wondering what we're doing here. I just want to remind the board that this is a show cause hearing about two violations. This is not a landlord and tenant matter. And what is before the board is that we've stipulated to the facts. Wabbit LLC was prepared to move forward and move forward with resolving this matter before we got to where we are now. And what is occurring is there is a dispute between the co-licensees, and Georgetown and West End is attempting to use this forum as a landlord and tenant to resolve a landlord and tenant matter, and to use it as a basis in litigation that is currently ongoing. So I would urge the board to look at this for what it is and to limit any testimony that's outside the scope of what this board needs to do, which is look at it for it being a show cause matter. And in terms of charge one, and there's two charges that are pending, and we were prepared to move forward and take it as a first secondary tier violation for charge one and impose a $250 fine, and for charge two, a $2,000 fine. And we would request that the board impose that. And also, as Mr. Showolf, I mean, he's entitled to his opening, but I'd request that that be limited in scope as to this specific incident.
All right, thank you. Mr. Showolf, your opening, sir.
Thank you, Chairman Anderson. As much as Costas' attorney would like to trivialize or minimize this particular matter, the fact remains that Costas is a repeat offender. This is, by my count, the 7th violation that Costas has had in various forms, including this would be the 4th, actually, violation of noise. I'm sorry, 4th violation of an occupancy violation. 4th one. This is not simply a landlord-tenant dispute. That would be an inaccurate description of why we are here. Costas has repeatedly flaunted and disregarded the rules. They have caused significant damage both to my client's business, and I have a witness here on behalf of the hotel, Mr. Kojo Abawaji, who's the general manager, who would testify as to the almost weekly complaints that they have received since Costas opened for business in 2018 regarding the noise complaints that the guests have made at this hotel. This is a somewhat of a unique situation where you have a hotel that operates, and then on the bottom floor is where Costas, which was supposed to be just an amenity for the hotel guest, has turned in, and I use the word menace, and I'm not, that's not an overstatement, a menace to both the hotel and to the surrounding neighborhood. We also have as a witness, Ms. Sarah Blumenthal, who is the president of the board of directors of a condo directly across the street, who entered into a settlement agreement with Costas as a condition of their opening their business, which they have, in the terms of which have been completely violated on multiple occasions, including now. The settlement agreement restricted Costas from operating during the Monday through Thursday till 11 p.m. and until midnight on Friday and Saturday. They have completely violated the settlement agreement, which is in the record, and the occupancy allowed has been repeatedly violated. They are not a first offender. This is an operation that has caused many problems in the neighborhood, has caused problems with my client because of the nonstop noise, which is the subject of these particular violations. And this is just one of many instances. So it's just not accurate to just brush it on the rug and say, hey, we're willing to pay we were guilty, we'll just pay a little fine and we're on our way. The board has warned, they have gotten away on 4 prior occasions with a warning and minimal fines for the same behavior. And they just continue to violate the rules and regulations. And I know this is a little bit of an oddball situation where you've got co-licensees, and one of which is fighting to have a harsher penalty than what the other licensee is. But given that there's been 4 violations, the code permits revocation. And if the board is unable to revoke the license just as to Costas, the rum bar, then we would request that the license be revoked, given the number of violations. This would be the 7th since in the last, I believe the last 2 years, 7th violation. It's in the record. And this is an operator that cannot be trusted, there's fights that break out. We have video from just 2 weeks ago of fighting. We have complaints again from guests, even as of the last week after these charges were filed. We have testimony from Ms. Blumenthal, who's going to tell the board, if she can be heard, about patrons that are making noise up until 2, 3 o'clock in the morning on the streets, defecating in bushes across the street, at the condominium, the trash that this business generates outside. As I said, they're a menace, and my client no longer wants to be associated with this particular business, and neither does the neighborhood. So our request is that the license be revocated or revoked, and that is authorized under the statute, under the code, because this is their 4th violation for the same offense, the same tier 1 violation.
Thank you, sir.
Mr. Chairman,
Yes, Mr. Grandis.
I would like to get a clarification for the record. I'm not familiar with the term co-licensee in the ABC, in the ABRA code. I am somewhat, are we to understand that these 2 attorneys are representing entities that are on the license that's issued from ABRA?
If I may, Mr. Chairman?
Go ahead, Mr.
According to the investigation, the license is held in 50-50 percentage ownership by the 2 entities. So there is 1 license with 50-50 ownership.
And how's that? I'm trying to understand.
And
is that through a legal document, or is that are each of these entities on the license?
Yes, Mr.
Yes,
Grandis.
yes. Both entities are on the license. That's correct.
It's my understanding, based on all other licenses, that parties apply for a license, and as you're aware, if someone applies for a license, if there is an entity that owns more than 10% of the stock, they have to be on the license. And so therefore, here it is that we have 2 licensees, and both licensees are on the license. But as I've stated before, it's as far as the agency is concerned, it's 1 license. And so, yes, there are disagreement between the 2 licensees. One licensee it appears, is saying that there's a fine and $250 fine and $2,000 for the second charge. That is what one licensee is saying. The other persons are part of the license is asking for revocation. And the way the board will look, at least the way the board should look at this, is that when the testimony is based on what's presented by the government, when it comes to penalty, the board will make a determination what is the appropriate level of penalty based on the violation. based on what's in the record and what's the violation. And so it will not be that entity A gets one result and entity B gets a different result. The board will issue a determination based on the violation, and that's what we will do.
Chairman Anderson, may I just clarify one thing, please? May I
Can we
clarify one matter?
clarify the actual?
I'm sorry, hold on 1 minute. All right. Let me have Mr. Sherwood and then you, Ms. Johannes. Since
Sure.
he had started the chip before. Yes, go ahead.
The two things, if I could clarify, please. Georgetown Suites does not own any membership interest or any other interest in Wabbit LLC or Costas, nor does Costas or Wabbit own any membership interest or ownership interest whatsoever in Georgetown Suites. I'm not sure how this was done. I was not around or involved when the liquor license application was submitted, but I know it was done by Ms. Johannes's firm. But I know you're Chairman, you had mentioned that there has to be at least a 10% ownership interest in the entities, and I just want to make it clear for the record, that is not the case here.
Well, as I'm saying, what hurt?
You can clarify.
Go ahead, ma'am. Go ahead.
Two entities can be separately as two separate entities as on one license, and that's what occurred here. So you oftentimes have situations where you have restaurants that are inside of hotels, the hotel itself and the restaurant separately as two different entities can be on one license, and they are termed co-licensees, and that's the situation here. And so I just wanted to clarify that you're correct in that, like, we're not intertwined, we're two different entities, but both entities decided to be on this one license together. If Georgetown Suites wants to surrender their ownership or surrender to this license and they want to be removed from the license, we're happy to have them removed. If that's the situation, and if that's what they're requesting, we're happy to do that.
But that's
not jurisdiction. I understand. That's not why we're here.
Right.
But
That's not in this hearing. The parties, if they, if the parties outside of this hearing can file a request with the board to remove certain entities from the license. And I know that Ms. Johannes knows the process to remove an entity from a license. All that the proper documentation is provided to the board, and if the documentation is provided to the agency will submit to the board, and the board will vote to have it done. But it will not be completed until the board has voted to remove it. So, but that's done outside of this hearing. But I just want to let the parties know that as far as we are concerned, this is one license. Whatever decision that's made by the board will consider the charges, the information that's presented, and the board will assign a penalty as the board thinks appropriate. For any case, if the board determines that it is so egregious, the board is empowered to take away the license. If after the information that's presented, if the board determines that the matter is so egregious, the board has that right to do that, whether or not it's asked by the government or any party. I just want to say that. But this is one of the first time I've had a hearing where we have two joint licensees, and they're in disagreement, and it's been presented to the board that there's disagreement there. Because
Mr. Chairman,
it can be on. Yes,
Mr. Chairman.
Yes, sir.
That's what I'm concerned about, as you just mentioned. I understand this show cause is regarding an investigation by our investigators as well as what's been filed by the government. We're not here to listen to disputes between co-owners or whatever. And I believe that we need to be very careful and focus just on hearing the owner's response, if they have one, to what the allegations are in the show cause, not about whether or not they can work together jointly as owners. So would you help us stay narrow to what we're here about this afternoon?
And I'm going to do that. I think what Mr. Showolf, I think his argument is that he's saying that all the parties agree that the violations occurred. And I hear I believe that what he's saying that based on the seriousness of the violation, he's telling the board that the board should cancel the license. That's what he's saying. Based on the seriousness of the violation, what he's volunteering to the board is to say that, yes, I think this is what I'm hearing, we committed this violation and it is so serious and egregious that you as a board should cancel the hearing. I'm sorry, the license fee. The other licensee is saying that this is a routine matter. We believe that based on the violation, that the board should impose, I think it says a $250 fine for the first case and $2,000 for the second charge. And I believe that, and the government is saying that the board should impose a penalty pursuant to the guidelines.
Right.
So,
Can we get clarity on the where we are with that in terms of, I know Mr. Sholoff said he spewed a whole bunch of violations and numbers, but like where we are and what this would be considered under each charge, so we can identify that, like for charge 1, it being considered a first secondary tier violation. I don't think that's in dispute.
Right. I'm
sorry.
All right.
Am I?
All right, this is where we are. The government is going to present its case. All right, the burden is on the government to prove. The government is going to present its case, and both sides, then the licensee will present its case, and the board will make the appropriate determination. But as I said before, it appears that what Mr. Showolf is trying to do, he's presenting evidence to say that this matter is so egregious that the license should be terminated based on that I'm admitting as a licensee. I think that's what I'm hearing as a licensee, that this matter is so egregious that the penalty should be, the board should revoke the license. And so I can't tell a party how they're going to respond to the charge. They respond to their peril. Where we are, the government is going to present its case, and once the government presents its case, then the licensee will present its case in response to the government. Okay, so that's where we are. Okay, so does the government the government is going to present its case. And once the government presents its case, I will ask the licensee how they wish to respond to the charges. And they can respond whichever way they want to. But the only person I can tell, the burden is on the government. The government has to present a case for the board to make a decision based on whether or not the government has met its burden. Now, if some other entity wants to help the government in presenting its case in response, I can't say you can't do that. I can only tell the government, present your case, so at least the board will have sufficient information to make a decision. Okay? All right. Do you have a witness or you wish to call? Mr. Sello.
Prior to so doing, in response to Attorney Johannes's question, I would proffer that the government's position is that these violations constitute the first secondary tier violation and the second primary tier violation within 2 years. I believe that information is consistent with and is identifiable in Government's Exhibit 1, the investigative report. And based on the stipulations, I would formally introduce Exhibit 1 into the record at this time.
And so admitted, as I stated, between as operation of law, it's part of the board record, so it is in that, it's in the record. All right, so do you wish to call a witness, sir, or?
No, Mr. Chair, based on the stipulations in the record, or the investigative report being in the record, the government will waive its witnesses at this time. However, we do reserve the right for rebuttal should it become necessary.
All right, fine. Ms. Yanis, how is it that you plan to respond to the charges as presented by the government?
Well, I believe that we have responded in that we stipulated to the facts. I think we're at the penalty stage, and I agree in that this is a first secondary tier violation for charge 1 within 2 years. This is a second primary tier violation within 2 years for charge 2. So that would mean for charge 1, that would carry a maximum, or I mean, the fine would be in between $250 to $500, I believe, and $2,000 to $4,000 is what the board could fine in charge 2, which is why we are requesting for charge 1 a fine of $250, and for charge 2 a fine of $2,000.
All right. And that's your defense. All right. So, since we have another party now, how do you plan to defend the charges, sir?
I've read this differently. I look at the Exhibit 1 of the government, and I see this particular charge being the 4th primary violation. There was a case dated April 17, 2021, where it was a primary violation having to do with allowed music to be played above a conversational level, and then a violation allowed occupancy greater than 25%, plus allowed more than 6 patients to be seated at a table. That was a primary violation of this nature. There was a warning given. On page 2 of Exhibit 1, there's case 20-CIT-00488, having to do with, case 20-CMP-00069, a primary violation of increased interior occupancy. That was a warning as well. And then there's another violation on February 7th, 2020, case number 20-CMP-00039, where it was an increased interior occupancy. And again, that would be the 3rd time of a warning. So unless I am just off base here, those violations, this would constitute the 4th violation, not the 2nd, within a 2-year period.
I think if there's
It's not an adjudicated violation.
okay, we can all Mr. Sello, do you have a copy of the case report?
Yes, Mr. Chairman.
And one of the things that I will have you do, I'll ask Ms. Fossbaum to give you the opportunity to share your screen. And so let us all look at the investigative history so we will all agree what the investigative history states in the sense of what violation this is. Because it appears that there's some disagreement. So I want the record to reflect what the board's investigative history states regarding this case.
Are you able to see my screen, Mr. Chair?
Yes, sir.
Okay.
And
I don't have a witness, but I will present to the board that we do have the violations that were cited by Attorney Showwolf. However, not all of these are being counted by the government in the investigative history. The first violation, 21 CIT 00026, that is a violation of an emergency order, emergency rulemaking. It resulted in a warning that is not being counted. In the second violation, case 20 CIT 00488, failure to follow mayor's order and emergency rulemaking, also primary tier, but because of the emergency rulemaking aspect of it not being counted against the license holder for these purposes. We had the third 20 CMP 00069, increased interior occupancy. That was a warning, as such, not being counted. 20 CMP 00039, the fourth, also increased interior occupancy, also a warning, also not being counted. 19 CMP 00174, operating a summer garden without an endorsement and failed to follow security agreement. And dancing without an endorsement, so similar charges to here, but that was also a warning, as such, not being counted. And the final six, 19 CMP 00118, operating a summer garden without an endorsement. And this one was a $1,000 fine, and this is the first primary tier that is being considered.
Thank you. All right. So that's investigative history. So that's where we are. All right. So, sir, how do you plan to call? And this is Mr. Shovell. Do you plan to call any witnesses, sir?
Well, I guess that depends on if the government is going to recommend the maximum penalty. If not, then yes, we would call witnesses so the board can understand exactly what we're dealing with here with regard to Costas Rumbar's operations and their continued flaunting and ignorance of the rules and the prior violations.
I believe in the government's opening. The government was directing the board to assign a penalty pursuant to the appropriate penalty as per the regulation. So the board, at least in its opening, what I heard was that the government was informing the board to look at the law and apply a penalty pursuant to the law. And as I stated before, the board can make a determination at any point to say that a matter, even if it's a first tier violation, if the matter is so egregious, the board could determine that the license could be we could remove the license if the board determined that a matter is so egregious.
Then I would request that I call a witness, Kojo Abawaji.
And Mr. Chair, are we limiting testimony to, this is about penalties, so are we limiting testimony as to this incident? Or is this just sort of a free-for-all? I would just request that we remember, because we have a list of witnesses here, and are they, I mean, I guess we'll hear them as they're called, but I want to make sure testimony is about this specific case.
Well, I believe that what's been argued, this is not because this matter is so egregious, because these are the previous complaints, and because it's so egregious, that the board should issue a penalty that is relevant to the issue. I think that's what I'm hearing.
That's correct.
So how far though is this testimony going to go? Are we going, this sounds like a protest matter. I mean, are we talking about different violations? This violation, is there going to be a limit into like scope?
Well, I think the bottom line is that the board, you can, if it's not a part of the investigative history, the investigative history for this case is in the record. And I believe that there's agreement that based on the investigative history, this is a first time violation for charge 1, and for charge 2, This is the second primary violation within the past 2 years. That is what the investigative history states. And I believe, I believe, and if I'm wrong, so I'm not gonna allow you to talk about 20 years, what's been going on. So
I think it's important that the board understands a little bit of the history, a little bit of the facts which give rise to these charges. The fact that despite the issuance of warnings, that this operator, Costas, does not seem to care whatsoever about a warning or a minimal fine, and that they're going to continue to violate whatever penalty or warning that the board may issue, that they're just going to continue on with the same behavior, that this behavior that they've been charged with has occurred even after they got charged with this current violation. It simply doesn't matter to them. And I think it's important that,
was also
hold on, again, I've not yet interrupted Ms. Johannes. I will not do so. I let her speak, and then I wait for her to be done. I would just ask for the same courtesy. That's all.
Sure, go ahead.
Thank you. So I think it's important that you hear from a representative of the hotel to show or testify as to the Costas' behavior, both before and after this charge, and the type of operator that we're dealing with, and the rampant complaints that have been lodged by hotel guests with regard to the noise violations and the behavior of the Costas patrons. I think it's important the board hears that and has that in context whenever it's making its decision as to the penalty. I think it's important that Ms. Blumenthal be able to be heard. She's a neighbor. They entered into a settlement agreement in 2018 with Costas that has clearly been violated. Now, whether that's for a different hearing, I'll leave that to the board. But she can certainly give some flavor and context as to Costas' behavior and its impact on the surrounding neighbors. I know she very much would like to be heard. I will be brief. I will not turn this into a 20-year history, but I think it's important that the board understands and hears what is happening with this bar, which was supposed to be just an amenity again for the hotel, but it's turned into a nightclub that's open till 3 o'clock in the morning with noise complaints on a weekly basis, as well as fights and other behavioral problems, pulling of fire alarms, things of that nature.
All right, are you done? I again want to just object to this whole line of how this proceeding is going and how questions are going to, and now we have a whole line of witnesses that are going to be presented, and I still am not clear about how that relates directly to what we're doing here in the matter before us. This sounds like a matter, it's a protest hearing essentially, and it's a free-for-all and this is also a contested matter. We've already stipulated to facts. I just believe this is really inappropriate for this co-licensee who also, is charged with the same violations, is now presenting witnesses to increase this fine. We've stipulated to facts. The board knows what's before them. I want to just leave it to the board and have the board decide.
As a co-licensee, as Mr. Chairman, you stated, whether we're in support of the government or we're opposing the government, we have a right to be heard. We are a co-licensee. So although the testimony may not be favorable to Costas or Costas may not want to hear it, I think we have a right to be heard on it.
Not appropriate for this. There's another way for you for that to be brought before this board. This is not the appropriate way. This is not the appropriate matter that's before the board. We're talking about a show cause hearing. We're talking, right now we're getting into completely other different sets of facts and having witnesses come testify as to penalty. I don't know when that's ever happened in the last, 5 years.
All right. The board is going to go in executive session just to get some legal advice from our counsel. So as chairperson of the Alcohol and Beverage Control Board for the District of Columbia, in accordance with DC Official Code Section 2574B of the Open Meetings Act, I move that the ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 21 CMP 00045, Wabbit LLC, Georgetown West End Castles Rum Bar, license number 109462. Pursuant to DC Official Code Section 2574B4 of the Open Meetings Act. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. The board will go into executive session. Please do not log off. I'm not sure how long we're going to be there, but put your camera on mute and turn your camera off. Put your microphone on mute so we don't hear what the conversation that you're hearing. But the board will go into executive session and we will return shortly. All right, thank you.
Thank you.
We're back in the record. All right, so we're back in the record, and this is what we're gonna do. There is already a stipulation regarding some of the facts for this particular case. If Mr. Sherwood, if you have a witness who can specifically testify about the incident that occurred on, if you believe that there are some factual situation that was not covered by the report, the case report, that can more so addresses the incident on September the 11th, you can have a witness who can testify about the incident on September the 11th. I do not want to hear evidence or any testimony regarding ongoing concerns. If there are any ongoing concerns, the licensee or any member of the public can file a complaint to the agency. The agency will send its enforcement division out to investigate it. And if it merits further development, then the agency would further the report to the Office of Attorney General for further development. So we're not going to have any testimony on continuing violations. Those are not appropriate for this hearing. Continuing violations, individuals are free to contact the agency every day. You can call the hotline. There's someone who manages the agency hotline. Has been managed, I think, almost every day, probably, I believe, through 4 a.m. in the morning, and we will go out and investigate it to see whether or not, and then further charges can be brought. But for this particular hearing, if you have a witness who wants to testify, further or to provide additional facts in the record about the incident that occurred on September 11th, then yes, we can have testimony from a witness who can more so provide the board with an additional testimony regarding September 11th, and that will assist the board in making a decision on what penalty, if any, should be imposed. And I believe that at least the government is asking that some type of penalty be imposed for the 2 violations, and there's agreement that there was a violation, that the licensee was guilty for charge 1 and also for charge 2. And so, but if you're stating that you believe that there are additional facts that occurred on September 11th, and the board should consider that in providing the penalty, then you're able to provide testimony on supplement the record with additional facts from September 11th there.
So, Chairman Anderson, if I may just clarify, you're not going to allow, or the board is not going to allow any testimony for purposes of aggravation with regard to the penalty phase. In other words, unless it relates directly to the September 11 charges, the board is not going to allow any testimony to show that this particular operator, Costas, has been having the same, conduct himself in the same manner before September 11th and after September 11th. Are you saying that only if it relates to September 11th, not September 10th, not August 18th, not October 11th, only September 11th, that's the only testimony will be allowed, and there's no aggravating factors that you will allow us to present evidence on that may impact the board's decision with regard to the penalty?
Yes, sir. What I can say in your closing, you can go over the investigative history to state what it is that we are aware of the investigative history shows. So you can, as part of your closing, you can talk about the investigative history. That's fair game because it's in the record what the investigative history is up to this date. But we don't need testimony on that. You can just point the board out to the investigative history, ask the board to consider in making this decision can consider the investigative history to date. But if there are continuing violation, the board has no independent verification that these violations have occurred. So therefore, community members can, because this is a show cause hearing, it's not a protest hearing. If this is a protest hearing, then we could have the litany to say this is a continuing violation. This is what's been going on over the years that they're there. But this is a specific show cause hearing to say this is an incident that occurred on September 11th. So we can have testimony regarding September 11th. In your closing, you can ask the board to take administrative notice of the investigative history. But we don't need testimony on the investigative history, on the history of this establishment, because we're aware of that. We just need September 11th and just September 11th.
And no testimony that despite the history and the violations that are set forth in the record, prior violations, testimony that Costas has, despite the warnings, the slaps on the wrist, had no impact whatsoever on their behavior. And in fact, it probably encouraged their behavior because they've gotten off so easily with their past violations. So that kind of testimony as to acts that occurred after the warnings and other fines, the board does not want to hear that.
Yes, sir.
Okay, well then we'll just state our objection to that ruling on the record and then proceed from there. I don't believe we have any testimony to offer specifically to September 11th. We've got a boatload of testimony for many, many, many other dates, but not September 11th specific.
And our position is, what the agency's position is, that I'm not sure when it's licensed up for renewal. And I'm not sure if you can protest. I'm not sure the process of the renewal, if both parties have to agree to jointly renew the license. That's not up to me to explain to you when the license goes up for renewal. And secondly, any member of the community, if they're continuing violation, any member of the community can contact the enforcement division of the agency to say that there's a violation. And each time a complaint is made, the enforcement decision would go out to see whether or not there's actually a violation and write a case report. And so the agency will go out at each time there is a complaint to investigate it, have a case report, and if that's sustained after a fourth primary tier violation, it says that it's automatic $30,000 fine or revocation. If there's a fifth, the license is automatically revoked. But that's the process that follows. But again, because it's a show cause hearing, we can only have testimony on the incident that occurred on September the 11th.
So even though this is a repeat offender on the same grounds of the violation, noise and occupancy, there's no testimony beyond September 11th.
Right, because we don't have any information on that. But as I stated before, the board will take administrative notice of the investigative history. That is part of the case report. That is their history, and so therefore, you in closing, you can make that argument to say, based on the investigative history, the board should impose whatever penalty based on the investigative history that we have in front of us to look at.
May I just take 2 minutes to speak to my client? You've asked me about September 11th, and I just want to confer with my client who happens to be with me as to whether there may be some testimony with specific September 11th. I said there wasn't, but I think it's better practice if I just confer with them. If I took 2 minutes.
We'll stay off the record for a couple of minutes until you get back, to make sure that you mute your microphones there.
All right, thank you.
All right, thank you.
Hi, can we go back on the record?
We're back on the record.
Thank you. I would like to call for very brief testimony on relating to September 11th, the incident. Michael Miller, he's on the list, and
All right, where's Mr. Miller? I see Mr. Miller. Do you have a?
Hello.
I'm sorry. Do you have a camera, sir? I see that you're on my screen twice.
Try. Is this okay, sir?
Yes. All right. Can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes. Yes, sir.
You're a witness, sir.
thank you. Could you please state your full name?
Michael Miller.
And Mr. Miller, are you one of the principals of the Savoy Apartments that's adjacent to the Costas Rum Bar operation?
Yes, sir.
And what is your relationship to the Savoy Apartments?
I'm a principal at Gelman Management. We own and manage the property. It's 203 apartment units, and our lot is adjacent and connected to the Costas Rum Bar and the hotel.
Okay. And are you familiar with the Costas operation and its business?
Very, very much so. I've been in the space numerous times for meetings regarding the operation.
And are you familiar with the violations that have been lodged upon Costas on the date of September 11th, 2021?
Yes, sir.
And what do you know about the incident that took place on that date?
Well, I think from my perspective, what's really important to understand is that I've been keenly aware of the situation because, for one thing, they built a structure that overhangs the property line. So I've been paying a lot, and there's constant noise complaints. So I've been
Objection.
I've been paying a lot of attention to what's happening there.
Mr. Miller.
Yes, sir.
If an objection is raised, you need to stop speaking.
I'm sorry.
Then we will. Then I'll make a ruling. I'll ask the nature of the objection, and then I'll make a ruling, and then based on the ruling, then I will let you know whether or not you should answer the question. Yes, ma'am. What's the nature of your objection?
This goes outside of the scope of the September 11th incident.
I'll give him some leeway. I think from what I'm hearing is that he's just stating why is it that he's familiar with this establishment. So I'm not gonna take evidence on prior to September 11th, but I believe at least I need to get some type of information. How is he familiar with this establishment? So I'll overrule the objection. But Mr. Shaw, just to remind you, this is only about the September the 11th, sir. Okay, go ahead,
Yes,
Go ahead, Mr. Miller.
Thank you. I appreciate that. Yes, it's just for background as how I'm familiar with the situation. What the key thing from my perspective is that, yeah, you've had multiple times now, including that night, basically 250% of the legal occupancy limit in that what's turned into a nightclub. And this is an unpermitted structure that has not been approved by DCRA. So the risk.
Continue my objection.
I'm sorry.
This is in reference to.
Sir,
the condition of the property.
All right.
He's testifying to the condition of the property. Mr. Miller, this is the condition of the property that existed as of September 11th, 2021, correct?
Yes, sir.
But listen, the purpose of this hearing is there are two incidents occurred on September 11th.
This is regarding
the occupancy, right?
Yes,
and
this
so
is directly related to the occupancy.
Hold on, sir. I don't want to hear about whether or not the building or the building, whether or not it has a proper permit from DCRA. That's not within our purview right here. You just need to talk about what is it that you knew? What is it that you're aware with about September the 11th?
I
That's
was
what I
just,
need to talk about.
yes, sir. I'm just specifically trying to bring to the board's attention that not only was there an over occupancy, but the situation in which that occurred and how egregious and dangerous that is. And I don't understand after they've already been acknowledged that this has happened before, and the board has penalized them for that. They go on and doing it again in the middle of one of the most dangerous circumstances I've ever seen, sir. That's all I have to say.
Did you recall receiving a complaint from your renters relating to excessive noise on September 11th?
I typically either get an email or phone call from my manager on the Monday after, weekends when things, when she updates me about once a week on the noise situation. So I can't tell you if she specifically notified me the day after, but I do get regular updates on the disturbances and which tenants are, having to leave the building because they can't stand the noise.
And you recall receiving a phone call or any other communication from your property manager on the date of September 12th or 13th relating to the noise at Costas on September 11th, which was a Saturday night?
In all truthfulness, I'd have to go back and look at my emails to verify that, sir.
All right, very good. Okay, thank you. That's all I have.
All right, thank you. Ms. Johannes, do you have any questions for this witness?
Yes, just briefly. So you're not aware of any calls, emails, messages you received regarding the incident on September 11th, correct?
If the board has time, I'd be happy to check my email right now.
I'm just asking you right now, you're not aware, as of right now, of any messages, emails that you received regarding the incident, is that right?
I'm not sure.
Were you present on September 11th to witness any incidents that may have occurred?
I'd have to check my calendar.
You don't know if you were present at Costa's?
No, ma'am, I don't remember every day that occurred numerous months ago, but as I said, if I check my calendar, I'm sure I could verify for you.
Okay, thank you.
No further questions?
No further questions.
Mr. Stella, any questions?
No further questions. I would call one.
No, I'm sorry. No, hold on. No, I'm asking the government.
Oh, I thought you said Showwolf. I apologize.
Yes, I would like to clarify a point, Mr. Chair. Mr. Miller, Assistant Attorney General Anthony Sello, on behalf of the government, nice to meet you, sir.
Nice to meet you.
As it relates to your testimony on direct, you talked about the structural capacity of that building. And I wasn't clear, number one, where the source of your knowledge was, and number two, the purpose of that testimony. Were you saying that it's not just a question of how crowded or what the permit is, but that the building itself is not structurally safe to have 250 people in it?
I'm saying no one from DC has ever inspected the newly created structure to affirm that it is safe. So without that, I would have to assume as a builder and developer in DC that there's likely issues with it if an inspection hasn't occurred or a permit wasn't issued for the work.
And you said that there's an overhang. Could you describe that?
I'm gonna have to object to all of this because I mean I understand that some of this was brought up during direct, but this is going outside of the scope of what is before the board right now in terms of the charges.
Respectfully, Mr.
Go ahead, sir. Go ahead.
Mr. Chair, this is information that I am trying to elicit because I do not know the context. But if there is a legitimate structural concern, then that would be a more severe violation potentially than it otherwise would appear on first blush, because we're not just dealing with fire escape issues and being raided for 99 people for that, but if there's actually some sort of structural concern, then that potentially does increase the issue before the board. And I don't know if that's the case or not, which is why I'm asking the question.
And I don't think that we can know from this witness either. I mean, this is a witness who's testifying as to what he believes, or I don't even know where this is coming from. So we're talking about a specific incident, and all of a sudden, this witness is testifying regarding some structure. So it's completely inappropriate and outside the scope. Again, I'm just objecting to any more testimony regarding whether it's the structure or anything else about that issue or that matter.
I think Mr. Miller is not testifying as an expert. It's not that my understanding is an expert as a structural engineer to say whether or not the building is structurally safe for that. I'm not sure if there was an issue regarding whether or not the structure was legally constituted, whether or not there is a permit, and whether or not there is, that's not relevant for, at least for this hearing. So I'm gonna sustain the objection. I'm gonna sustain the objection. You have another question you want to ask, Mr. Silo?
Just, Mr. Miller, from a foundational perspective, was your testimony based on a lack of permit only, or what was the basis, if any, for your testimony beyond a lack of permit?
Objection.
Hold on a minute. Hold on, Mr. Miller. Go ahead, ma'am. Go ahead, Ms. Johannes.
Yeah, I'm going to object to the question in terms of relevance. We're talking about the structure still. I think that you've already ruled on the first question. The second question still regarding foundation or the structure. We're still talking about a structure, which has nothing to do with what's before the board today.
Mr. Chair, you
Fishing expedition, essentially.
He's not an expert, and I agree with that. I'm just trying to determine if there is a basis that is admissible or not. And it may be that there is no basis, at which time I'll move on.
I'm going to sustain the objection again, because I think part of the problem that we're having is that I think we're getting too far afield for the issue. I think that both parties have agreed that there was a violation in the sense that they exceeded the occupancy. So I'm going to sustain the objection. Do you have another question?
No further questions at this time.
All right, thank you. Mr. Sherwood, I'm sorry, any questions by any board members? And we don't need to have any questions on the structure. But any questions by any board member? And the board members have any questions based on the questions that were asked by the attorneys? Okay, hearing none. Mr. Sherwood, any redirect there?
No.
Thank you very much, Mr. Miller, for your testimony. Do you have another witness there?
Just one.
He's your only witness?
Yes,
or you have another? Or you have another?
I have one more witness.
You have one more witness. Okay,
Yes.
Who's that witness there?
Kojo Abawaji.
Where is Kojo? I'm sorry. What's the last name again?
Abawaji. I'm sure I mispronounced that, but
I'm seeing a different last name on my screen, so that's one of the reasons why normally when I look at my screen, it helps me pronounce the name, but I'm seeing a different name.
you're seeing another person. He's borrowing a computer.
All right, so can you raise your right hand, sir, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes, I do.
All right, so can you have the witness identify and spell his name for the record, please, sir?
Mr. Wawaji, would you please identify yourself, state your full name?
My name is Kojo Abuaje, and I am the general manager at the West End.
Can you please spell your name for the court reporter, sir, please?
Say that again.
Can you please spell your name for the court reporter?
First name is Kojo, and the last name is Aboagye.
Thank you. Go ahead, sir. Your witness.
Mr. Abawaji, where do you work?
The Georgetown Suite, West End on 1121 New Hampshire Avenue.
Okay, and what is your position with Georgetown Suites?
I am the general manager
How long have you been the general manager?
since 2012.
And briefly, can you describe your duties and responsibilities as the general manager of the Georgetown Suites Hotel?
Basically, general operations of the hotel. I do guest relations, housekeeping, and maintenance of the hotel.
Are you also involved to some extent with regards to the Costas Rum Bar down the lower level of the hotel?
Yes, this is basically tenant landlord relationship.
And are you familiar with the incident that took place on September 11, 2021, which is the subject of these proceedings?
Yes.
Okay. And did you receive, you meaning the hotel, did the hotel receive a complaint from a hotel guest regarding the noise level from Costas relating to the September 11, 2021 operation?
Yes. On September 13th, we received an email from Hilton about a guest who has sent.
Objection. If I might.
What's the nature of the objection, ma'am?
Hello? Sorry.
Yes, go ahead.
Yes. Yes. My objection is regarding, I believe the question or the testimony is about to be regarding noise. There is not a noise violation right now. The two charges pending are not noise violations, and he's about to go into some noise complaint.
Well, the facts in the charge relate, the case report has to do with the initial complaint was a noise violation received at the IBRA hotline.
You were not cited for noise.
I'm gonna overrule the objection. I don't know where he's going. I mean, again, this is about the incident on September the 11th. All right, so I don't know. So I'll just give him some leeway to just hear. But if you can raise the objection again, Ms. Johannes, but at this junction, I'm going to overrule the objection. But go ahead, so you can answer the question.
Okay, so we received a complaint from a guest who stayed on September the 11th from Hilton, and the guest says that the nightclub was so bloody noisy. This is a complaint we received from a guest on that day.
And is that a typical complaint that you receive from a guest?
Yes.
Regard to the Costas operation? And how many of those complaints do you receive typically each week?
It's once a week.
I'm going to sustain the objection. Again, this is about September 11th. So if you, I need you to talk about specifically the incident occurred on September 11th. What occurred? This is not, the charge was a noise violation. So if you want to talk specifically about the two charges, then you can testify. But so let's not have testimony on receiving noise violations, that whether or not he's aware of what occurred at September 11th, and how did he become aware of what occurred in September, the charges that they were fined for September 11th.
Yeah, Chairman, may I take just one moment to speak to my client? 1 moment.
Well, sir, I mean, no, sir, you can't. Although this is an administrative proceeding.
Fair enough. I have nothing. I have nothing further to ask the witness.
All right,
Chairman.
All right, thank
you.
Ms. Johannes, do you have any questions of this witness?
I'll just ask the witness, did you observe anything on September 11th at Costas personally?
Did I what again?
Do you observe anything regarding the charges that are pending that cost us personally? Did you personally
No.
observe?
No.
I have nothing further.
Mr. Fellow.
Mr. Abawaji, you don't work at the hotel 24 hours a day, do you?
I'm sorry, Mr. Shaw. Not you, sir.
Oh, Mr. Cello. I hear Cello and I'm thinking Showolf. I apologize.
Okay, go ahead.
No questions at this time.
Any questions by the board members? Mr. Sholoff, any redirect?
Briefly, Mr. Abawaji, you don't work at the hotel 24 hours a day, do you? Can you hear me,
There's a
sir?
question. I can hear you. I'm not sure if he's.
Oh, he's having a computer issue. Mr. Abawaji, you don't work at the hotel 24 hours a day, do you?
No, I don't.
You don't live at the hotel, do you?
No, I do not.
You don't observe Costas 24 hours a day, do you?
No, I do not.
That's all I have. Thank you.
All right, thank you. Thank you for your testimony, sir. Do you have any other witness, sir?
No other witnesses.
You all right?
Yes.
All right. So this is where we are now, closing argument. So the government, they're closing, if you're honest, and Mr. Shaw. And at this juncture, I'm asking the parties to inform the board what it is that they want the board to do. Go ahead, Mr. Fellow.
Thank you, Mr. Chairman. Ladies and gentlemen of the board, may it please the board. The facts in this case are undisputed. The investigative history is undisputed. The only question at this point is what the appropriate penalty should be. The district is specifically requesting a fine within the standard ranges before the board for a second primary tier violation and a first secondary tier violation. It is understood that one of the licensees is requesting enhanced penalty above and beyond that based on the specific factors and aggravating concerns in this case. The district does not object to the imposition of such a penalty, but is not specifically requesting any such penalty at this time. Thank you.
Thank you. Ms. Johannes.
Wabbit LLC and the government was prepared to move forward with an OIC today. We're here simply because there's a dispute between the co-licensees. I don't believe in the last 5+ years that Abra has encountered an issue like this. But I will say in this specific matter, yes, the investigative history does speak for itself. I want to specify and to make sure that the board does take into consideration, as you all know, warnings and OICs are entered into and are given for specific reasons. And those reasons are not dug into or looked into further. And in this matter, there's 2 charges that are pending before the board. It's first secondary tier violation and a second primary violation. And I would again request that the board, in considering charge 1, impose a fine of $250, and with charge 2, impose a fine of $2,000. That's all.
Mr. Sowell.
Thank you. I understand this is a bit of an unusual circumstance that the board and the parties find themselves in that you have a co-licensee who is requesting that the license be revoked. But that's indeed what we are asking. This license should be revoked, and not for any wrongdoing by Georgetown Suites, but because of the wrongdoing of Costas. You look at the investigative history. This is the 7th violation. The majority of the prior violations, I believe all but 2, have been warnings. The board can see the impact that the warnings have had on this particular operator, Costas. And the answer is none. Nor will any will fine for this behavior. It's obvious when you have in a 2-year period, 6 prior, now 7 violations, that simple warnings, minimal $250 fines, $1,000 fines is going to have 0 deterrence on this particular operator's behavior. It's obvious. I'm sure they would gladly take a $250 fine, a $2,000 fine. They made more than that by having 250 people dancing in their bar on September 11th. A $2,000 fine and then another $250 is a pretty good business deal. I guarantee you this operator would take that in a second, considering the profits and the money that they made off of the violation of the 250 people that were in that space. If this were a one-time violation, then I could understand Ms. Johannes's arguments that this is a landlord-tenant dispute and that we have some beef and we're out to get our co-licensee. But this is not a one-time violation. This is the 7th in 2 years. So we no longer want to be affiliated, and maybe this is a different forum for a different day. But we no longer want to have a liquor license for this particular location with this operator. As a co-licensee, I think we have the right to request revocation. This is not as simple as a landlord-tenant dispute. This is solely related to the behavior of Costas. You have not once heard me say during this entire presentation that any of their behavior violates the lease. I've kept that separate. This is not a lease dispute. This is an operational dispute. This is a dispute because my client is legitimately concerned that the negligent manner in which Costas has operated his business and its complete disregard for the rules is jeopardizing its own liability, because God forbid there is some further problems and my client is a co-licensee along with Costas. Briefly, given the past violations that are clearly set forth in the investigative history, we'd request that the board impose the harshest penalty possible with our request and our consent, which is revocation of the license. Slaps on the wrist, minimal fines is not going to change the behavior, and you're going to find yourself right back here with an "I told you so." And I base that simply on the 7 violations in the past 2 year period. Thank you very much.
All right, thank you. The record is now closed. I'm going to ask this, but I don't think it's necessary in this case. Do the parties wish to file proposed findings of fact and conclusion of law or waive their right to do so? I think in this particular case that, and I'm just stating this because the factual situation is there's no new facts. There's stipulation of facts, but that's the right of the parties.
The government would agree with you, Mr. Chair.
I would agree so long as our co-licensee does.
We agree on. Chairman.
All right, thank you. The record is now closed. All right, then, as chairperson of the Alcoholic Beverage Control Board for the District of Columbia, in accordance with DC Official Code Section 2574B of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 21 CMP 00045. It's Georgetown in West End Costas Rum Bar, pursuant to DC Official Code Section 2574B4 of the Open Meetings Act, and deliberating upon case number 21 CMP 00045 Georgetown in West End Costas Rum Bar for the reasons cited in DC Official Code Section 2574B13 of the Open Meetings Act. Is there a second?
Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Mr. Grandis?
Edward Grandis, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed, I hereby give notice that ABC Board will recess these proceedings to hold a closed meeting in the ABC Board Conference Room pursuant to Section 2574B of the Open Meetings Act. Thank you very much for your presentation today. This is a first impression case for me as board chair, and we will deliberate. We'll issue a decision within 90 days. Thank you very much and have a pleasant evening.
Thank you.
Thank you.
All right, the next case in our calendar is case number 21 CMP 00036, Champion Kitchen, license number 103055. This case has been rescheduled to April 27, 2020 at 10:30 a.m. at the request of the respondent with the consent of the government. We have now come to the end of our day, and I will now close the record officially. As chairperson of the Alcoholic Beverage Control Board for the District of Columbia, in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on March 30th, 2022, for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulation, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for March 30th, 2022, as published in DC Register on March 25th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett is second the motion. I will now take a roll call vote on the motion before it's now been second. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed, I hereby give notice that ABC Board will hold this aforementioned closed meeting. Pursuant to the Open Meetings Act, notice will also be posted on the ABC Board hearing room bulletin board, placed on the electronic calendar on ABRA's website, and published in the DC Register in as timely a manner as practical. We are adjourned for the day. I would like to thank the members of the public who have participated in this hearing today. Also thank the ABC Board members who have also participated today. Thank you very much. We're adjourned for the day. I direct all board members to return to executive session for further action. Thank you very much. Have a great day.